Mail previous lordship, my lord, I pray for listing these two cases today, my lord. This,
Today? What
my
is
lord,
the
this
urgency?
matter relates to my lord. These two petitions.
No, why not tomorrow?
My lord, today, because my lord, today
No,
is the
why
day-
not tomorrow? That answer.
Yes, my lord.
Not what is the matter
Today
about.
is the last date fixed for my lord, counseling and for admission, my lord,
For
3rd of October, my lord.
for what?
For my lord, first year MBBS course, my lord.
MBBS is over by 30.
No, because that notification
Gogoi?
29.9, my lord. Notification 29.9.
Have you extended up to beyond 30?
Yes, my lord. My lord, notification states, my lord, 29/9/2023.
And
Because
why have you come at such a last
my
minute?
lord, these two petitions, they were already granted, my lord, admission.
For
On-
BDS, the cutoff date is different, not 30. It is
BDS.
BDS.
No, MBBS and BDS. My
Mr.
lord,
Gogoi, you check up.
yes.
No, it's BDS.
Yeah.
Otherwise,
Selected
we
candidates
do
for
not
BDS.
intend to entertain all
My
these.
lord, I am submitting, my lord, that on my lord, my lord, 3/9, my lord, they were already granted admission, my lord. They are imparting, my lord, MBBS first year courses, my lord, in Tezpur and
So if
another.
they are imparting, you continue with it.
Yes, my lord,
Why
because
should
they
you
have
bother
issued
us
their
today?
press list there under TCL OBC category, my lord, that in the final list, their name is not there. But they have already been granted admission, they are importing. My lord, there might be some problem.
Don't shout, please.
I'm sorry.
Your shouting will not make your case stronger. Huh?
I'm sorry.
Tell it in
Probably,
a
my
more
lord,
better voice.
Probably these are the candidates who have been found to be not eligible as per the committee's report. 7 candidates were found.
Most likely.
Yes. So
My lord, they given, my lord, the manager certificate issued by the concerned, my lord, tea garden, as well as the, my lord, the legacy data
What
connecting.
legacy data? This is not NRC.
My lord, that's correct. my lord.
Medical admission is not NRC with
My lord,
legacy data and all.
My lord, that I have placed on record.
Sorry, we are not inclined. First, tell us, Mr. Gogoi, does the cutoff date survive as on today? If
no,
yes,
for
we'll take up.
MBBS, it
If
is
no, we are
there.
not taking.
Only for BDS it is there.
This is MBBS or BDS.
My lord, mine is MBBS, my lord.
Then we'll take up tomorrow.
Tomorrow.
Whatever is necessary.
Obliged.
For listing on Friday, man.
Listing all, give it.
May it please your lordship, with the consent of the other side, I beg to mention item number 16.
60.
16.
Adjournment.
Adjournment.
60.
16.
Matter of which year?
2022.
Okay. Your name, please.
MS Hussain on behalf.
MS Hussain, petitioner adjourned. Yes, madam.
Wait, please, Your Lordship.
Much
Lordship, I'd like
obliged.
to mention item number 29 of the day.
29. Matter of which year?
2013, Lordship.
2000.
Much obliged.
May I please your lordship?
19 and earlier, please don't make mention.
May I please your lordship? Not with the consent of the other side, Lord. I beg to mention item number 40 and 41,
Item of which year?
2023.
20.
Because
You please give the number and your name.
it is not for listing, Lord. I have, Lord, in this case, I was supposed to take steps, Lord. But there is a little mistake in the first title page, Lord. I have to correct the same and accordingly.
See, Mr. This mention is an encroachment of judicial time. Please hurry up. We are allowing every mention. Why are you unnecessarily wasting? Listing, give it to the court master. Adjournment, 2019 and earlier, no adjournment. Before
I'm not seeking
rejected. Yes, next item. Call item 1.
May I please your lordship? My lord, I beg to mention contempt case.
No, it you rejected.
Item 1 for motion.
It did you.
May I please know, I beg to mention item number 12.
Well, want adjournment.
Yes, my lord. See one second. That
Okay,
may
your
be
name
fixed.
लिखिए वो
12, my lord. Highly obliged.
Board नाम कितना ले लो. Item 1 for motion.
Yes, Mr. R. H. Chaudhary.
This is for compassionate appointment, your lordship.
Compassionate appointment.
Impugn order is page number 41. your lordship.
Why is the matter pending for more than 1 year? Every time it is adjourned on your behalf. This writ petition,
Actually,
it was first time listed on 15/6/2022.
earlier
Invariably,
writ
whatever it is, invariably it's an adjournment on behalf of the petitioner, and on some occasion none appears for the petitioner.
once, your lordship,
So if it is compassionate appointment, we take it up with some urgency. But if this is your approach, why should we take it up with urgency? Must be you don't need a compassionate appointment. You can wait for more than 1 year. Now it's a 1 year, 3 months now. You repeatedly seek adjournment. I don't think there is any necessity of admitting this petition.
Some point,
Sorry,
at that point of time, twice occasions, your lordship, my
not
wife was,
twice.
wife was
No, your wife cannot be sick for 15 months, mister. Don't tell me that. Show the medical papers that she was sick for 15 months. Let us see.
not 15.
Don't make those incorrect statements. 15-6, prayer of petitioner adjourned. 21-6, that is 22, no representation. 24-8, a list along with something at your behalf. 25-1, adjourned on the prayer of the petitioner. 24-7, adjourned on the prayer of Mr. R.A. Chaudhary. Why? Where is the compassion for this petitioner on behalf of the learned counsel appearing for him? Compassionate appointment is always, I think the whole, yes, Mr. Saikia. I think compassionate appointment is at the earliest. So if you take adjournment, don't appear for 15 months, why should we take it up? And or why should they take it up? You must be happy without any job. Mhm.
2022.
See, we take a very lenient view of compassionate appointment, but some compassion should also come from the petitioner side also. Please answer. It's stated that this is a matter of claim for compassionate appointment, and the learned counsel for the petitioner to explain as to why adjournments in the matter was sought for on 15/6/2022, 21/6/2022, 24/8/2022, 25/1/2022, and 24/7/2023, 25/1/2023. And in between, on 21/6/2022, none appeared for the petitioner. List again.
Item 2.
Yes, item 2, what is this matter?
In this matter, regarding item,
Saini Bhuya, name sounds familiar, medical admission.
no, yes, Lordship.
Uh-huh.
But Lordship, I want to mention about,
Claims that grandfather is Lalit Bhuya of Nurvariti estate. That matter.
I am not much aware of
And
the
where the
facts.
garden says that there was no such laborer as Lalit Bhuya. I think it's that matter.
Lordship,
Regarding
may I
Saini
pray?
Bhuya, they have filed a preferred and read appeal.
Who had preferred?
Saini Bhuya.
Okay, let him prefer.
Appeal has been stayed.
What has been stayed?
Appeal in the appeal.
Our order has been stayed.
Lord.
Saini Bhuya is continuing.
Lord.
Continue.
Subject to outcome.
Lordship, I want to pray about item number 2 and 3 to be adjourned for the day as learned counsel, Mr. R. Majumdar informed me to over telephone just
2 and 3.
now to.
But 3 also read appeal.
Yes, Lordship. Medical,
No, 3 also read appeal has been filed.
But only 2.
Only two. Lord.
Only 2.
Vishaka,
3.
no.
Okay, adjourn.
bless.
To be listed again. आपको 4 weeks तो ना लगे.
Listed.
Adjourn.
Item 4.
Pharmacy council to provide as to why it has not been given.
Registration, presently, the Assam Pharmacy Council is not functioning. The register as well as the other executive members, their tenure is over, the election has not been held. some litigation is pending. So, my lord, only some office bearers are there. They are not in a position to register anybody as on date. They don't have the capacity.
Council is not there.
Let them wait for some time, my lord, because of the situation, my lord.
It's stated by Mr. B. Gogoi, Learning Council for the Health Department, Government of Assam, that at present the Assam Pharmacy Council is not functioning. And it is also stated that regarding the constitution of the Pharmacy Council, some litigations are also pending. In view of such statement, adjourn.
My lord, not for a long time, because they are,
How long, Mr. Gogoi?
Let it be after 3 weeks or after the Puja vacation. In the meantime, we'll have. to
Adjourn
discuss
for
on the
3 weeks
government.
as paid for.
my lord, in the meantime, if you also permit me, the notification by which the minority board has been made defunct, that has been challenged in this Delhi High Court.
Minority board? You are
Minority
asking for
Education Board.
registration of
Minority Education Board,
minority?
Education Board. Yes, Namto.
This is
So that
minority.
is not the issue here. My lord, is regarding registration in the Assam Pharmacy
That's why.
Council after completion of the intern.
We are not dealing with any minority issue here. Hmm. What is the prayer? To register the petitioner under the provisions as pharmacist. I think it's the only registration. There is no minority element here.
Only our difficulty is that 12 months has.
Mr. Buragohai, if the council is not there, just because petitioners are minority, can they be registered?
No, not that.
And if yes, who will
There
register
is
them?
one issue which is, according to him, it is not the issue for Assam. In Delhi, a case has been filed against the order of the.
No, then
government.
you go in Delhi and appear and make your submissions in
Right.
Delhi.
In the meantime,
How can we take note of an issue in pending before the Delhi High Court?
my lord, the issue, it is similar to our issue, my lord. The
No,
government.
no. Here you want registration by the Assam Pharmacy Council as pharmacist.
My,
Okay.
my lord,
He says Assam Pharmacy Council is not functioning.
not functioning.
So we'll have to wait for some time till the Pharmacy Council is in place.
It is.
It is not the matter whether your client will be registered or somebody else will be registered. It's a matter where no one will be registered.
No, that is why, my lord, we have prayed here in the prayer portion, your lordship, the last interim protection, if your lordship can consider that. That means if they can give us for the provisional.
Mr. Buragohai,
All right, my lord.
suppose the judges are not sitting,
Yes.
can the
My lord.
filing
My
authority
lord,
take up your writ petition?
Only difficulties, my lord, if they do not form it within a particular period of time.
Then you file a writ petition seeking a direction for formation of the council. We'll take it up. If you give us that jurisdiction, we'll ask them. Then also maybe direct
That
them
is correct, my
to
lord.
form the council.
My lord, if they do not form it, some difficulty will be on our part. That is why I.
Mr. Buragohai, we understand everything.
I know.
We asked you one question.
My-
Suppose the judges are not sitting, can the filing section take up a writ petition?
Would your lordship.
Your prayer is of something of
Make
that
a,
nature.
give a date, my lord.
Date,
That will be after vacation, my lord.
as paid for list also. Date is okay.
Obliged.
10th November. Item 5.
Yes, what is item 5? Some amalgamation.
Not
No,
amalgamation, Lordship. The
amalgamation,
petitioner, Lordship, he had appeared for the recruitment process of postgraduate teachers. And he had given preference in Tinsukia district. Lordship, because of the wrong entry in the system, Lordship, one candidate was shown to be
Wrong entry in the,
system, Lordship.
whose system? Their system.
Yes, the system that was conducted by Amtron.
Where is the wrong entry? Which page?
That is, Lordship, it will be reflected from the communication of the inspector of schools, Lordship.
Page number?
Page number 66.
66. Inviting. Yes, Mr. Yu Sharma, what do you say?
No, I have to take instruction regarding this letter.
What
What is the
instruction will
outcome
you take?
after that?
No, don't take us, bring any instruction. Tell us what we have done pursuant to this one. Because it appears the inspector is very clear. Gayatri Saikia was given 320 marks and she was in #1 merit position. Then your authorities make a correction and Gayatri Saikia also agrees that she did not get 320, she got 306 marks. So she is out of the merit position 1. Next man is the petitioner. Since when you are kept it pending? Since July, why? We dispose it of with a direction to the director to pass a order. Look into the record. Heard Mr. S.K. Das, Learned Counsel for the petitioner, also heard Mr. U. Sharma, Learned Counsel for the respondents in the secondary education department.
1, 2, and 4.
Who all are there? Right. And Mr. P. Saikia for Additional Deputy Commissioner Education, Tinsukia. The petitioner Pritimoni Datta participated in a selection process for postgraduate teachers in the higher secondary schools in the political science subject for the Tinsukia district. For the Tinsukia district, as per the advertisement dated 27/12/2022. It is stated that in this mark of 300 something, it's in the selection process.
It is the SS marks, BA marks, MA marks.
No,
BA.
The cumulative
Total.
assessment in the selection process.
Total marks.
In the cumulative assessment in the selection process, the petitioner secured 312.66 marks. Whereas another candidate, Gayatri Saikia, was shown to have secured 320.18 marks. And accordingly, in the merit list, Gayatri Saikia was placed at serial 1, whereas the petitioner Pritimoni Datta was placed at serial 2. But subsequently, it was realized that Gayatri Saikia did not secure 320.18 marks, but in fact, she had secured 306.5 marks. In this respect, there is a communication dated 17/7/2023 from the Inspector of Schools, Tinsukia, to the Director of Secondary Education, Assam, which is extracted as below. A reading of the extracted communication from the Inspector of Schools makes it explicit that the authorities are also of the view that Gayatri Saikia was incorrectly shown as serial 1 in the merit list for the subject Tinsukia, for the subject political science in the Tinsukia district. And if the serial 1 was wrongly shown, logically, the serial number 2, Pritimani Datta, would have to be now considered to be at serial number 1 of the merit list. In fact, as per the communication, even Gayatri Saikia admits that she ought not to have been at serial number 1 as she had secured only 306.5 marks in the selection process. This writ petition is instituted on the grievance that nothing further had been carried forward pursuant to the communication dated 17/7/2023. In view of the limited grievance being raised, writ petition disposed of with a direction to the Director of Secondary Education, Assam, to take note of the communication dated 17/7/2023 and pass a reasoned order thereon. If the contents of the communication is correct, that the Gayatri Saikia was incorrectly shown at serial number 1 in order of merit for the subject political science in the Tinsukia district. And in the meantime, the mistake had been rectified, it would now be Pritimani Datta, the second candidate in order of merit, who has to be considered to be at serial number 1 in merit. Director to take note of the said aspect, pass a reasoned order, and if the petitioner is otherwise entitled for selection and appointment, consequential orders be also passed. Requirement be done within a period of 1 month from date of receipt of the certified copy of the order.
Lordship, may kindly add one
Nothing
more
more.
in the unreserved category.
Nothing more.
In the
Nothing.
Obliged.
We don't know. Director will look.
Obliged.
Because your case unreserved is not stated there in the communication. That's why.
This category.
Item 6 for admission.
Obliged.
Item 6, yes, who appears?
Sixth, Lordship, the University Authority and Higher Education Department has something is going on, Lordship, regarding the percentage part, Lordship. Staff ratio part, Lordship. So, Lordship, at least 1 week time. Yesterday
One
also I have
time.
talked, Lordship.
Adjourn on the prayer, Mr. Ki, go for the respondents in higher education. You want to say something, Mr. Pukul?
Lord, it will take some time, at least 1 month, that work out. That staff ratio, 1:1.5.
No, I have not gone through the matter. I have only taken note that some staff
Lordship.
ratio has to be worked out.
2 weeks time.
2-3 weeks.
3 weeks. Similar prayer is also made by Mr. P.J. Phukan, Land Council for the Guwahati University, as prayed for list after 3 weeks.
Almost there.
7 and 8.
My lord, there are 2 repetitions, my lord. One pertains to rejection of promotion, the petitioner in violation of this honorable court's order. And the other petition is, my lord, pertaining to my lord superstition in promotion. My lord, his junior has been promoted.
Did I hear this matter earlier?
Yes.
Yes, sir.
There is an order list for further hearing.
In WPC
Who
285.
appears, Mr. Gogoi? Or you appearing?
Gogoi appeared, Lordship. Just now
No,
he is-
last, some other earlier occasion, Mr. Gogoi appears for the
Gogoi
health
appeared,
department.
Lordship. Right now he is on late duty in another court.
After some time.
After some.
9 and 10.
May I please, Your Lordship? This matter relates to your lordship selection and appointment of principal, your lordship.
Adjourned on the inconvenience, Mr. S.P. Sharma, Land Council for respondent number 6. Where is Mr. S.P. Sharma?
My lord,
Yes.
my lord, could kindly pass over the matter for the time being. My senior SP Sharma is on legs in another court, my lord. Sorry, my lord.
But we have already adjourned
Too close.
twice or thrice on behalf of Mr. SP Sharma.
My lord, he will.
Every time we cannot do it.
I apologize, my lord. He is on legs in another court. He'll do the matter today.
I have no option. Your Lordship.
But tell Mr. Sharma
My lord, he is there.
to
my
give some preference to this court also.
lord. My lord.
Always preference to some other court may not be the answer.
Item
He is
11.
also waiting for his turn for the last several dates. And every time it's adjourned on behalf of Mr. Sharma.
My lord, this matter, last occasion, last month was given, but we have not noticed the order. So my
Sorry?
lord, we have not aware the order. And moreover,
How
my
can you
lord,
be aware when you did not
yes,
appear?
yes, my lord. Moreover, my lord,
See,
we have
none
also
appears for the
missed,
elementary education department. So how can he be aware what order was
yes.
passed?
So my lord, can
So
another
now how
three-
much time do you want?
3 weeks, my lord.
Huh?
3 weeks.
2 weeks, my lord. Senior is saying 2 weeks.
Moreover, we have misplaced the pilot, so kindly.
You request Mr. Sharma.
I'll give you copy.
Kiman,
2 weeks.
2 weeks granted to the elementary education department to file the affidavit on the prayer of Mr. Ganesh Pegu, Land Council, Standing Council. List on so and so.
item 13.
Madam Buzurbarua.
May I plead your lordship? The matter pertains to the appointment of president. in the
M.
school.
Khan, you have filed your
Yes,
affidavit.
my lord.
Can you hear the matter today?
Yes, yes.
Education department, who appears?
Only do regarding.
Yes. The petitioner name was recommended for the post of president as a serial number 1. And according to the notification letter issued by the inspector of school, 2 names may be recommended for the appointment of president and vice presidents. Accordingly, the parents teacher meeting was organized and the petitioner name was recommended as 1, serial number 1. And the respondent number 89 name was recommended as serial number 3. Instead of that, the respondent number,
What is wrong with that order?
my lord,
The guardian selected the petitioner, but respondent number 7 was made the president school managing committee.
yes,
What is wrong? Is it necessary that whosoever the guardian chooses, mandatorily that person has to be made?
Lordship, kindly come to the annexure 2, page 25, my lord. There is a notification dated 27 October
We have seen
2021.
those notifications, yes.
Approval of the guardian minister is required, my lord.
No. Inspector school in consultation with the parents and guardian.
Yes, my lord.
That is the language.
That is,
So
yes.
consultation doesn't mean whosoever they recommend, it is mandatorily only that man will be given. They'll ask them once.
No, only 2 names may be recommended.
So
According
now-
to the notification.
So now what is your
The
case?
respondent name was recommended and the serial number 3, my lord. I have no
No,
idea.
these are not a merit selection. That he is 3 not entitled, I am 1 entitled. These are serial number is on a random basis. Anybody can be serial number 1. There is no selection on merit.
Yes, my lord, but that is true.
Any
But
other
only
ground?
2 there is a clear direction that 2 names may be recommended. I have no objection if the serial number 2 was appointed in place of serial.
No, Madam Buzurgurwa. When 2 names should be given, they have given 3, 1 must be taken out.
Yes.
Anybody 1, 2, 3 can be taken out. Not that only 3 has to be taken out. Nothing like that. Because these are not selection on merit.
Yes.
Had there been a merit assessment, then we understand. If out of 3, 2 has to be retained, the last one will go. But these are all random selections.
But approval is given.
Only
to the-
thing, it is by chance that your name is in number 1, and it is by chance that the other man is in number 3.
But
This
according-
argument will not hold good. Any other good ground?
Good
Any
ground
other legal issue?
Otherwise it's not there, but
Find out. If it is there, we'll hear you.
but yes,
Suppose
but the approval of the guardian minister.
we
the guardian
understand.
Minister approved both the names, but he did not put any date over there. Who's
Date.
Not date.
That will be at the best irregular. It will not make it illegal.
Like if date is my name is approved
Understand.
before then.
Understand,
That
that is
is-
that will make it irregular, not illegal for an interference by the court. Try to find out, we'll adjourn it. Because when the names are sent on a random basis,
Yes.
without any merit assessment of serial 1, 2, and 3, then, and you say out of the 3, only 2 can be retained. At the best, we can ask you, why did you not retain the petitioner and retain the other 2? That question we can, at the best, we can ask you.
Because as per the circular, the inspectors have to send only 2 names.
Understand?
That is why.
No, no.
one and-
Mr. Chisti, you are supposed to give us 2 names. You give us 3 names. We have to delete 1. Suppose we have to delete 1, we must have some reason why we are deleting X and not Y and Z.
That should have been there.
Some reason must be there. Otherwise, this deletion will also be arbitrary. Tell us that. If you have a reason, that is good enough. I think we cannot help you anymore.
The reason
Uh,
must be submitted by the government.
If you don't have a reason, you have to go back to that stage. Out of the 3, you retain 2, reject 1 by providing a.
Ultimately, the president was elected by the deputy. Power has been given.
That is not an arbitrary unfettered power. It's not the basis on the whims. It is basis of some material. The response, it is stated that in the meeting of the parents, guardians, and teachers of the PMHS school, 3 names were recommended for the post of principal,
President.
for the post of president. But under the guidelines that hold the field, only 2 names are to be recommended. In the circumstance, the authorities in the inspector of schools had retained 2 of the names and rejected the 3rd. That candidate who was rejected as the 3rd rejected candidate is before the court by way of this writ petition. If 3 names were presented, 2 retained, 1 rejected by the inspector, the reason thereof be made available to the court. The records containing the reason thereof be made available to the court.
All the records.
This so.
After vacation.
After which, immediate test.
Otherwise, we have to go back to that stage.
Item 14,
The records containing the reason of retaining 2 and rejecting the 3rd be produced before the court. That graduate teacher.
Yes, my lord, here, my lord.
Your client is Emmy. Your client is Emmy.
Emmy, amalgamation.
Emmy after amalgamation. Yes, where are the guidelines? Education department.
But one notification, my
Mr.
lord.
Sharma, I think we are asking you something. Where are the guidelines regarding what will you do with a teacher of the ME section after amalgamation for the post of headmaster or principal?
Principal.
Principal of a higher secondary school.
I got one notification, my lord. Here it is says, my lord, next page, 30, my lord,
30, huh?
30, my lord, sub rule, my lord, 23, my lord, that they can be according to their qualification, they can be allowed to take classes accordingly.
No, that is okay. We are not on taking class. But what do we intend to do regarding their status of being a graduate teacher? এই রুলখন আছে নহয় এইখন থাকিব We want the departmental council. Please come forward. Because based on what you submit, we have to examine the respective. What are the guidelines? What is the law? Are you prepared, Mr. Sharma? It's a serious issue, I'm telling you. It will have an implication not only in the one matter. We'll almost have to lay down the law on this thing. You can't just based on one communication from one principal here and there to get the matter determined. This is insufficient. See, first come to Rule 12 of the Secondary Education Provincial Rule 2018. That will be page 32 of that blue book. Post of principal in provincialized shall be filled up by direct recruitment. Okay, it is direct recruitment, not promotion.
Yes,
From the candidates amongst the cadre of postgraduate of senior secondary school and higher secondary school and graduate teachers of higher secondary school. So either postgraduate or graduate teacher. Then who is a graduate teacher? You come to page number 21 of that book. Graduate teacher means and includes the category of assistant teacher, classical or higher secondary school or madrasa, for whose appointment the minimum qualification is graduate. So, does the assistant teacher of the ME school may be having a graduate qualification after amalgamation with the higher secondary school meet the requirement of section 2I? That's why on the last occasion we pointed out this is a serious issue. Please prepare, come prepare. Otherwise you cannot answer this question. Yes, Mr. Chisti. I think somebody will have to answer this question. Is there any previous judgment of the court on this question?
When I could not find.
Had this issue already been decided?
So far as the ME is concerned, there is no judgment. In the high school, there is already that has been placed.
Which one? Let us see if we can draw something from that.
That is 19.
Hmm.
19.
Citation to key judgment. Mr. Roy, when you give us a copy, you take it back also after the hearing, so that you can give it us on the next day again. Don't leave it here.
Graduate in Arts, Science and Commerce. My client is my lord, the petitioner is graduate since his appointment as science graduate. Later on he became
No.
and she is
Madam
graduated in
Saikia,
2011.
the concept graduate teacher is a well-defined concept.
Yes, ma'am.
Any teacher having the qualification graduate may not be a graduate teacher. So
Petitioner,
from your line of argument that I am a graduate, so I am a graduate teacher may not be correct. Because we'll have to examine as per section 2I of the rules of 2018.
yes,
If you meet, we'll accept it. Which paragraph, Mr. Roy?
Para 12 and para 19, your lordship will be. ready.
Para 12. huh?
Para 12, para 12. This is 2003 rule is para 12 and 2019, my lord, may I see.
no, right.
It says the recruitment of my lord, headmaster and principal are in one process. And graduate
Just
teacher
a
is.
minute.
1904. Mari, ito ni copy ito.
No, this was between high school and higher secondary school.
But
Here we have a peculiar situation. They are appointed teachers in a ME school. ME school gets amalgamated with the higher secondary school. After that, what happens? What happened to the teacher of the ME school? Does he become a graduate teacher?
No, my lord, because the definition.
No,
this
you will say
definition
no, Madam Saikia will say yes. So we want the department to say what is their rule.
that-
As per clause of the amalgamation, my lord, seniority is restored.
no,
Clause of the amalgamation.
Seniority is there. What
Yes,
about
sir.
the status?
That is, my lord, that now the notification I have given, here,
See-
according to their qualification, they can be allowed.
No. Is every law graduate a lawyer? Same thing. So every teacher having the graduate degree may not be a graduate teacher. Because graduate teacher is a well-defined concept under the rules.
Yes.
So unless you fit into that concept, who knows the answer?
The teachers who have been appointed in the ME school as a science graduate teacher, they comes under the definition of graduate teacher because their minimum qualification at the time of the appointment was graduation. But in rest of the teachers, my lord, their minimum qualification at the time when they were appointed in the ME school was not graduation. So therefore, my lord, by that.
No, just a minute. Graduate teacher means and includes the category of assistant teacher, classical teacher of higher secondary or senior secondary school, or high madrasa high school, including amalgamated higher secondary and senior secondary school, for whose appointment the minimum qualification is graduate.
In arts, science and commerce.
High school and higher secondary, high mother.
You read the definition again.
Yes.
Read the definition 2-3 times, see what meaning comes out.
Graduate teacher means and includes the
Not
category
once, you read it more than once, because
yeah.
I read it twice. Second occasion, I saw something different.
Graduate teacher means and includes the category of assistant teacher, classical teacher, or senior secondary arts school, junior college, or high madrasa or high school, including amalgamated high secondary or senior secondary, and high school for whose appointment the minimum qualification is graduate in arts, science, commerce from the recognized university, including them.
So now read it once again. See the meaning you got first time, and the meaning you will get it on the second time. Is it the same, or it is you see something little different? Frankly speaking, I saw it a little different.
In regards to Malad, the including the
No, no.
amalgamated. Yes.
So one way of looking at is the day the school got amalgamated. Suppose you want to recruit this assistant teacher who originally may be from a ME school. What is the qualification, required qualification?
Earlier, Malad,
If the required qualification would be non-graduate, then this man is out. If it is graduate, this man, by virtue of the amalgamation, he'll be in.
Malad.
Conjointly read with the definition.
Malad. If that inclusion of the amalgamated high school.
See, had the school not been amalgamated, this man is not a graduate teacher. We accept your argument.
Yes.
But section says graduate teacher means assistant teacher
Malad.
also in an amalgamated school.
Malad.
So now after amalgamation, he becomes an assistant teacher in an amalgamated school. So this assistant teacher after amalgamation, if you want to recruit, what will be his qualification?
But the qualification,
No,
the
no.
requirement of
No,
minimum.
don't go somewhere else. Same teacher, after the school is amalgamated, if you intend to recruit, direct recruitment, what will be the required qualification?
After amalgamation, it
The-
becomes the higher secondary school, amalgamated higher secondary.
Mr. Kaushik, we are not interested with a different answer. And as long as you don't answer, we are going to repeat the question again and again and again.
No, your lordship.
So
is-
you have no escape from that. Tell us, imagine one teacher is there, ME school teacher. School gets amalgamated with a higher secondary school. This teacher is having some position in the amalgamated school. Now, suppose this teacher would not have been there from before. Same teacher. You want to recruit him now. What will be the qualification?
The qualification of a graduate teacher in a high secondary school.
So now the amalgamated ME teacher also acquires the same status now. So if you go by this definition, including an amalgamated school, he is a teacher whose required qualification for recruitment is graduate. So, and the person also has a graduate. So he is a graduate teacher. Why not? Why can't you take that that interpretation?
When the amalgamation took place, my lord, that then 2003 rules was in force. 2003
No.
rules. Yes.
That's why I told you. You read the definition that
My lord.
we deliberately asked you to read the definition 3 times.
Yes, sir.
You read it once
My
again.
lord. Lord, if your lordship kindly finds 2003 rules also.
No, no, we'll not go to it.
Well,
We will, this is recruitment for principal under the 18 rules. We will take note of only 18 rules.
No, to ascertain, my lord, whether the status of that teacher
No,
who has been amalgamated
Mr.
from the ME school.
Kaushik, we understand what you are trying to submit.
My lord.
But you cannot come out of the definition of 2I
My lord.
if you take that argument. Read it once again.
My lord.
Graduate teacher means and includes category of assistant teacher. Person is an assistant teacher.
Yes.
No difficulty with
No
that.
difficulty.
Where of higher secondary school or secondary school or high madrasa or a high school,
Including
including means
amalgamated.
also of a amalgamated. So an assistant teacher of a amalgamated school
For whose appointment?
for whose appointment means whose appointment, or not where he was originally appointed, of the assistant teacher of the amalgamated school. Whatever is his qualification, if that qualification is graduate, that man from that day he becomes a graduate teacher by virtue of this definition. It's a legal fiction. Originally, he may not have been where he entered, but the day you converted it to an amalgamated school, that their legal fiction goes in his favor by virtue of this definition. So he earlier status of an assistant teacher under the 2003 rule goes, and now he will be covered by this.
But if we read rule 12 and 13 together, Malad, there is a distinction, Malad.
Yes, let us read.
Rule 12 provides Malad recruitment to the post of principal and procedure thereof, Malad. And rule 13 provides for the post of vice principal. Now, Malad, here your lordship finds the qualification, Malad.
Which one? 13 or 12?
Sub-rule 3,
You are
Roman
reading,
2.
reading 13 or 12?
Page 32 of this book, Malad. Rule
So
12.
rule 32, huh?
Malad.
Minimum qualification.
Minimum qualification for appointment to the post of principal in higher secondary school and senior secondary school shall be as follows. Educational qualification, I'm skipping it, Malad. The candidate must have rendered at least 15 years of service as a postgraduate teacher in any provincialized higher secondary school, or the candidate must have
Mr. Kaushik, we understand what you are saying. We
5 years.
No, we will go to that
Hello.
step by step.
Yes.
You can't mix up the two.
No. Why I'm trying to submit, my lord, that
know.
there is a distinction in case of
Mr. Kaushik, still we don't accept your argument, but what will happen is there will be a legal fiction in favor of this ME school teacher that he also becomes a graduate teacher. When it will become? From the date of the amalgamation. So from the date of the amalgamation, he must have 17 years. If you read this one, see, candidate must have 17 years of teaching experience as graduate teacher. Means from the date he becomes a graduate teacher, he must have 17 years.
in any higher secondary school.
In any higher secondary school. Amalgamated school is a higher secondary school. So this is how petitioner may be excluded. Not because petitioner is not a graduate teacher, but because the petitioner may not have 17 years of teaching experience as graduate teacher. But the earlier period cannot be because that was as a non-graduate teacher.
But rule 13, the vice principal, my lord, there is a distinction that the status with regard to the ME school amalgamated teachers. My lord.
Where is it? Which
Rule
provision?
13, sub-rules 2C, my lord.
C.
Sorry, my lord, D, my lord. D. In cases of amalgamated higher secondary school, the assistant teacher of ME, MB having requisite qualification and 15 years of
This is
teaching
another
experience-
provision.
My lord.
This is a
What I'm
separate.
trying to, my lord, if your lordship kindly
Understand.
just make appear.
We are responding it straight away. This is a separate provision because your rules of amalgamation says the headmaster of the ME school will become the assistant headmaster. It has nothing to do with the teachers.
Right.
Whosoever was the headmaster of the ME school after amalgamation will become the.
Yes, yes.
So for him, this provision is.
No, Mala, that is for headmaster. This is for principal, Mala. Rule D says, Mala, about the amalgamated schools. So the schools which has amalgamated with the high secondary school,
Yeah,
for
in
vice
case of
principal, my lord,
amalgamated assistant teacher or ME school having.
in both ME and MB and amalgamated school,
This is for vice principal.
vice principal. And now, after serving as vice principal for 5 years, the ME school teacher directly can go to
Maybe.
the principal.
Maybe.
So, Mala, what I'm trying to understand, Mala, this way, Mala, that
We'll explain everything.
yes, the status by virtue of the amalgamation will
See,
not change. Mala.
No, it has
Because in
changed.
one,
No,
so if I
your
remember
rules
correctly,
are
Mala,
so complicated. There are various compartments, various circumscribed in different manners. The ME school teacher is eligible also to be the vice principal.
yes,
Okay. What you'll need a combined experience of 15 years. in the ME and after amalgamation.
Yeah.
You become the vice principal.
Yes.
Once you become the vice principal, your status
I become eligible for
changes. By virtue of that status, if you work for another 5 years, that will be an indirect method to also be
participate
a
in the selection.
principal. But if you want to directly participate, and mind you, I initially pointed out it is direct recruitment, not
Yes,
promotion.
direct.
Suppose you want to participate directly without being vice principal and all. We'll have to interpret the rule that it needs 17 years as graduate teacher. When will you become a graduate teacher? On the day of the amalgamation. Unless the person also had the status of a graduate teacher prior to the amalgamation. If it is prior, then yes, if earlier the person was not a graduate teacher, he becomes a graduate teacher by virtue of this definition on the day of the amalgamation. So 17 years will be counted from that day.
In case of science teacher, there is no dispute because
Doesn't
ME
matter.
school science teacher, they enjoy
Mr.
the
Kaushik, we are not interested. We are interested only with the
Yes,
case.
but no, why I'm saying, Malad, in case of graduate science teacher in a ME school, their minimum qualification was graduation and therefore they enjoys the same pay scale, graduate scale of pay, like as the high school teachers.
That is another question, whether they are graduate teachers or not.
They are graduate
By-
because 1981
By which rule?
Malad, elementary rules.
Mr. Kaushik,
Malad.
suppose to, after my retirement,
Malad.
I take up a post. I'll get the same pay. Will I still remain a judge of the High Court? No. So only scale of pay is not the criteria.
Absolutely not, Malad. But the
Graduate
distinction,
teacher is a well-defined concept under the law. You'll have to get into that definition.
that the graduate teacher, their minimum
So a
qualification,
science teacher may be paid the graduate scale of pay.
because their minimum qualification was required to be a graduate.
Still doesn't matter. Same example if I put it again.
Malad.
The qualification of a High Court judge and that post is also same. That will also not make it. So wherever the concept is defined under the law, prima facie it appears, you'll have to fit into that definition. You can't take all and sundries and say, yes, he's also so. Think over.
Malad.
We're not deciding, just don't try to bulldoze through.
No, I'm not. This word, Malad, appears,
You
the
just read the whole entire concept, not only these 18 rules, your earlier rules, your amalgamation rules.
Yes.
And this is a complicated issue. It will have a far-reaching effect.
Yes,
I'm
yes,
telling
absolutely, Malad, absolutely.
We'll decide it.
Because this inclusion of the word amalgamated high secondary school, Malad, gives an indication.
What
That's
to do?
true.
It is your rules.
Yeah, that's true, Malad. And this has
And
actually-
mind you, when you interpret a rule, every word has to be given its meaning.
because
You cannot leave out any word.
in the earlier 2003 rules, that word was not there. That
So from henceforth it is.
yes, 2003 rules
And
simply says, well,
this judgment will also not help you. It was under the 2003 rules. Also, to some extent, it is that definition of graduate teacher appears to be same under the 2003 rule. That's the
only
thing.
this part was not there. Inclusion of the amalgamated high secondary. There it was very clear, Malad, that the minimum qualification, the initial minimum qualification.
So
should have
only
been-
way we can read is these ME school teachers, immediately on the school being amalgamated, there is a legal fiction in their favor by virtue of this definition. They become graduate teachers.
It appears.
They become. By law, they become, although there may not be any order. Number one. For being the vice principal, there is a detour
Yes.
procedure available. 17 years of total experience. It doesn't need to be a graduate teacher. Total experience. 15 years, become the vice principal. Once you become the vice principal, if you continue for 5 years, you become eligible to participate for principal. Suppose you don't become the vice principal. Okay. And
Directly one.
you are not recruited as a graduate teacher. Then what happens to you? This is the question we are examining. I think that 17 years is the only catch.
Yes, 17
That
years
will
is
go
the only
against,
catch.
possibly go against the petitioner.
And 17 years, my lord, that word amalgamated high school, high secondary school is not mentioned. But however, in the
No, by
the vice principal is a promotional post.
forget about vice principal. By virtue of this definition, he acquires the status of a
The
graduate
definition
teacher.
gives him, my lord.
Huh.
Huh.
Law gives him, not
Yes,
definition. Law
but
gives him.
yes, my lord, the again the rules of recruitment in Rule 12, that does not say about the amalgamated as it has
No,
been
no,
said in Rule
that
13.
doesn't say. That only says one thing. 17 years.
17 years
Bas,
as in
that's it.
higher secondary school.
Day you become graduate teacher, 17 years henceforth.
My lord.
That's the only
17
way.
years of teaching experience. It
As
also-
graduate teacher.
as graduate teacher in any higher secondary school. But it did not distinguish, my lord, whether the
Doesn't
total
matter.
experience would be
Doesn't matter.
in, my lord, why I'm saying, my lord, Rule 13 says so. Rule 12 doesn't say so. My lord, that
Very
of
well.
course your lordship has
That's-
to examine that.
That's what we are
Well,
examining.
that's-
We are examining 12. We are not
Yes.
examining 13.
Yes. To understand, my
If
lord,
there is any candidate who had taken the detour method of vice principal, that will be different.
that will be
He will be in a different category.
yes. His eligibility to become a principal has become by virtue of a vice principal,
Vice principal, not because of
Not
his
because-
teacher or graduate.
not because of that. First he adopts the promotional post, then he goes to the direct recruit. I think, my lord, we'll have to file an affidavit to that effect also. my lord.
I think
The-
something will be
something-
required because this, I don't think this is the only case.
If I remember correctly, my lord, in one case,
Madam Saike has raised this now, but tomorrow there will be hundreds of such
yes,
cases.
yes. Because in one case, if I remember correctly, we have filed one affidavit. In Musumi Bora's case, my lord, where we have taken a stand that by virtue of, that was a high school path, ME school to high school. In that, my lord, we have taken a stand that by virtue of the amalgamation, the status of the ME school teachers would not change. Because the graduate
No,
scale of pay has,
it will change. By virtue of this definition.
this, here it is an including high secondary. That was a high school. So definition says including amalgamated high secondary school.
What
So-
amalgamated high school is not
No,
given
no,
again. What kind of rules you make? Hmm.
High secondary and senior secondary or senior secondary.
No, no, including amalgamated higher secondaries and senior secondary and high school. Amalgamated high school is also there.
Or a high school including amalgamated high school.
Yes.
Here high school
No, no.
amalgamating
Read the complete, including amalgamated higher secondary and senior secondary and high school. Means amalgamated high school also.
including a amalgamated high secondary school
Why are you stopping there? Read the next two words
and
also.
senior secondary and high school.
And high school.
And high school.
High school is also
For
included.
whose appointment?
So you withdraw that affidavit. That will be a wrong affidavit.
That was under 2003 rule, my lord, because 2003.
No, we are on 2018, of course.
So this status under this rule, my lord, will have to play. Because 2003 rules did not say anything about amalgamated school. It says the minimum appointment, initial appointment, minimum qualification should be graduation at the time of initial entry. And 1981 elementary rules, they were governed under the 1981 elementary rule earlier. So that rule says the minimum
I think
qualification was higher secondary.
whatever it is,
Yes.
2I creates a legal fiction.
Yes,
2I creates a legal
2I.
fiction in one way or the other.
True. To that aspect, my lord, right.
Third, MSN psychiatry.
To say something, my lord.
You want to something more? Yes.
Yes, my lord.
What do
Number
you want
one,
to
my
say?
lord, this is, my lord, not a question of appointment of regular principal, because it is a direct appointment. Here, my lord, only in charge. Petitioner is the senior most person.
Madam Saikia,
And my lord.
there
only
is
one.
a judgment.
Both of them not completed 17 years.
The-
Neither me nor she.
It doesn't matter. That also will not matter.
17 years. And my lord.
There is a judgment, I think,
Yes, my lord.
Julha Salih, if I remember the name correctly. To be an in charge, you should also have the
Have the
qualification
qualification as
of a regular.
regular.
No, I have
So
the
that-
qualification. I have the qualification for regular appointment, my lord, because he is master degree, he is B.Ed also. And she has been graduated in 2011. I am graduated since the date of initial appointment, 91.
Now, why did you give it to Mr. Roy's client? She says that he also doesn't have the qualification.
He has, my lord, because
He has. No, Madam Saikia says neither the petitioner nor the respondent has the qualification.
No, my lord, qualification means she is graduated, my lord, in 2011. I am graduated in 91, when initial appointment. Secondly, my
That
lord,
does not-
17 years, both of them.
Madam Saikia, we are not hearing those arguments. The reason is law requires 17 years of teaching as graduate teacher. This is number one.
Yes.
Doesn't matter what qualification you have or when you had your qualification.
17 years.
So question will be when you became a graduate teacher.
91.
A man doesn't become a graduate teacher by acquiring a graduate degree. A man becomes a graduate teacher only when he satisfies the definition of graduate teacher as per the rules.
That I could
This
not
is the
understand, my lord,
distinction
because
we are bound
Yes,
to take.
but I could not understand much, my lord, because here, my lord, definition is
What can we-
any graduation
Madam
from
Saikia,
arts, science or commerce.
If we have not understood, how can we help you? You tell us.
Arts, science and commerce from a recognized
You
university.
please go through the rules and come back if you have not understood.
So I cannot be termed as one of undergraduate because I'm graduated when I am a science teacher.
Same example, Madam Saikia. Every law graduate is not a lawyer.
But she
So
was
now if
initially
a
bemused,
if a
and she
man
graduated in 2011.
man who has not approached the bar council with a law degree claims around and say, I am also a lawyer, will anybody accept it? Same thing. I am a graduate, but do not meet the requirement of a graduate teacher. How can you be a graduate teacher only by virtue of qualification? You are a teacher with graduate degree, but not a graduate teacher.
Why, my lord? That I could not understand. Why
Mr.
I am
Kaushik, please make her understand.
Why
You sit
not,
with
my
Mr. Kaushik, he'll tell you. we cannot take a law class here. Yes, next item. Akili, order the
Immediately after vacation, my lord. In the meantime.
Mr. B. Kaushik for the Mr. P. K. Roy, Learned Senior Counsel for respondent was so and so. The petitioner is an assistant teacher in the erstwhile ME school prior to the amalgamation. And it is stated that the petitioner had also acquired their graduate qualification in the year
From the initial appointment, 91.
in the year 1991. No, graduate degree.
Graduate degree, my lord, prior to that, my lord.
Graduate degree even prior to his initial appointment in the ME school in the year 1991. Petitioner raises a claim that by virtue of being an assistant teacher in the erstwhile ME school and having a graduate degree even prior to the appointment, the petitioner is a graduate teacher. And it being so, as the total teaching experience of the petitioner from his date of initial appointment in the erstwhile ME school, along with the teaching experience after the amalgamation of the school with a higher secondary school, the petitioner meets the requirement of 17 years of teaching experience as graduate teacher. In the circumstance, a question for determination would be as to whether the petitioner having the graduate qualification and being a teacher in an ME school is a graduate teacher under the law. Graduate teacher is defined under section 2I of the rules of 2018. Full stop. The definition of graduate teacher as provided in Rule 2I would make it discernible that if the post where the teacher was appointed at the time of appointment did have the minimum qualification were graduate, comma, such teacher would be a graduate teacher under the rules. It is submitted by Mr. B. Kaushik, Learning Council for the Secondary Education Department, that for the post of assistant teacher in a ME school when the petitioner was appointed in the year 1991, the required qualification was not a graduate, although the petitioner may have been a graduate, and therefore he is not a graduate teacher during his tenure of assistant teacher in the ME school. But a reading of the definition of graduate teacher under Rule 2I makes it discernible that an assistant teacher in an amalgamated high school, a higher secondary, secondary or high school would also be a graduate teacher if the qualification for such post requires the qualification of a graduate. Accordingly, on a query being put as to what would be the required qualification of a teacher, of an assistant teacher, of an amalgamated higher secondary school, the reply given is that the qualification would be graduate. As the petitioner has a graduate degree and the required qualification for the post of assistant teacher in the amalgamated higher secondary school would also be a graduate degree, the respondents to submit as to why the petitioner should not be considered to be a graduate teacher on and from the date when the ME school was amalgamated with the higher secondary school. Okay. The reply be made in the form of an
Can be graduate or postgraduate, because high secondary school.
No, we are on graduate. Don't mix up.
No, category of teachers.
Moment you mix up, you can never answer any question in this world. Go.
Lordship has recorded that I answered to that effect. So,
you answer only this much. Don't go for this. When a postgraduate comes, we'll deal with the postgraduate separately. They are not before the court.
He passed BSc in 1989, madam. Based on
We go. The affidavit be placed on record before the next reasonable date, list on so and so.
Item 15.
can it be after vacation?
when it will be listed, madam? He will give.
Mr. Kaushik, please explain Madam Saikia. She is frankly says that she is unable to understand our question.
I'll try.
Yes,
Lordship में kindly pass over the matter for time. He like.
Item 17 with personal appearance.
That dancing matter, my lord.
Yes, you were the principal of Haji Anfar Ali College.
4-5.
Is your college in a different classification as far as discipline goes from any other college under the government of Assam? Same standard. Suppose these boys would have done something a little more than dancing after a particular function. What would you have done? See, for dancing, you had dismissed out of the college. You are a very, very strict discipline college. What would you have done had they done something a little more than that? Say they would have slapped a teacher. What would they have done? Suppose after, while dancing, one teacher goes to them, say, please don't dance, and the student slaps the teacher. What would the college have done? Please come forward.
The disciplinary actions were taken.
We are not asking you what you have taken, what you know. What you have done, had one of these students slapped a teacher, if the teacher would have asked them, please don't dance in the school, college, what would they have done? What action would have been taken? Please answer. For dancing, a man is dismissed from the college, you are rusticated out. Suppose repeating the question third or fourth time, one teacher goes to the students and asks them don't dance, and the student slaps the teacher. What punishment would have been given?
So the matter will be taken to the disciplinary action committee.
What punishment would have been given?
As per recommendation of the disciplinary action
Mr.
committee.
Principal, we may like to place you under suspension. Be a little careful before you answer. Your conduct of your college appears to be more indisciplined than the indiscipline of the students. Are you operating a college in Afghanistan or in India? See, some students after function say they use that public phone, the public system for putting a music and say dance. You could have asked them not to dance. End of the matter. Will you throw them out? You are supposed to be nurturing the students, or you are supposed to be draconian on the students? Have you not spoiled the future of two or three students? Are they not our future generation? Please answer. And you are a government college. You get money from government, I think. Government college.
Yes.
You are getting a salary from the government. Government of Assam, I think.
Yes.
Does the government of Assam believe in this kind of actions? Are you operating colleges for this purpose? That's the answer of the government of Assam.
Sir, it was the decision of the staff.
So therefore, as you have no control over your staff, we place you under suspension. You are not fit to be a principal. You ask them to take disciplinary action against you. Take action against you, man. Place him under suspension immediately.
Sorry, sir. Will withdraw the suspension order.
Are the educational institutes do not have a responsibility to the society, to the country, to the constitution? Or you are an island of your own in the middle of the Pacific?
We will withdraw the expulsion order.
Whatever, how many years they have lost, who will compensate that? How many years you have lost? They say repeated to 2022, meaning they have 1 year, definitely we have lost.
1.5 years.
So you are not fit to be a college because you don't understand the students. You don't understand their requirements. You don't understand how to deal with a student. Students are at a very tender age. One boy may be a little misguided here and there. What is the responsibility of the college and the teachers to bring them on track? Where is that responsibility of an institute gone? And you are very bravely taking stand through your lawyer. We are a very, very disciplined college. As if other colleges in Assam are all indisciplined. Cotton College is indisciplined. All the colleges in Guwahati are indisciplined. You are the only disciplined college in this world. Are you, what is happening in Afghanistan? What is the term used for these kind of things? Don't you feel for these students? Suppose we understand that this is such a rogue student that after giving them reminders and warnings, several of them, one after the other, still they are not mending themselves and it is spoiling the other students. So we have to take this hard decision. We understand that. Possible. One student or two students dancing somewhere after one function, that will be farewell of a teacher. Get out of the college. And you say your staff is doing it. Very enlightened staff you have. The Director of Secondary Higher Education Assam to make an inquiry and submit a report on the affairs of the Haji Anfar Ali College as to why students are being thrown out, rusticated or what, rusticated from the college for the mere act that 2 or 3 of the students were found dancing after a particular college function was over. The college authorities seeks to justify the decision on the ground that they are a very, very disciplined college. If it is so, are we to understand from the director that the rest of the colleges in Assam are all indisciplined colleges? And there is only one disciplined college, namely Haji Anfar Ali College. The report of the inquiry be submitted on the next reasonable list next week. If any college authorities are found to have exceeded their authority and jurisdiction, the director to suggest what appropriate remedial measures are intended to be taken. This next week. A copy of the order to Mr. Mayor. The college can do without one principal for a day.
Item 18. Copy as Council for Education.
But here I prefer some time to file a.
The director to also look into the aspect of sense of proportion in the action of the college authorities. Yes, Mr. Puragaister.
They are supposed to file it. The review is required.
For some further time. New case.
How much, Mr. Gogoi? For the
Finance department.
Finance, Mr. B. Gogoi, finance prays for how much time?
3 weeks.
4 weeks time to file affidavit. They always start for 4 weeks.
After
Item 19.
19 also it's time for filing affidavit.
3
weeks time to file.
3 weeks. Ganesh Pegu, Elementary Education Department, 3 weeks time to file affidavit.
Item 20.
And where is Mr. Bhuya gone?
Yes, Bhuya. Yes, Bhuya.
Yes, Bhuya, Higher Education Department.
After vacation is up. Kundu, item.
Yes, Hazarika, where is he? Then appears for the petitioner list again. Next item.
21.
Okay, item 20, I'm appearing, my lord. Sorry, my lord. I was in code number 6, my lord. Sorry.
It's gone, Mr. Hazarika. What
I
to
can
do?
understand, my lord. Sorry.
Say what you say on the next date.
15 November. 15 November.
Yes, the next
Malad-
item 21, who appears?
My lord, No, this matter your lordship will remember. My lord, Before my senior, sir, my lord, my senior Mr. Kane Soti is in Lakeland court number 2, my
In
lord.
21,
21, my lord. Time being, my lord.
time being.
My lord.
Ask Mr. S. Bhunya to come.
Yes, yeah.
Ah,
22.
Lordship, that in respect of item number 22, Lordship, extra copy has not been served on me, Lordship.
Don't file your reply.
Lordship, I have already served the extra copy through my,
Mr. Das, we are not an inquiring authority whether served or not. You sort it out amongst yourselves. Adjourn on the prayer of parties. If they don't serve, don't give your reply.
23 for orders.
Who appears? Yes, Mr. SMT Chisti, your name appeared on the earlier one.
Service report. I think I was directly by the court, but my name is not reflected in the call list, so I have missed this item. I think notice, the service is yet to be completed, I think. Anyway, Lordship,
Yeah, SMT appears for the sole respondent. That's a last order.
last order. My name is not in the call list, so I have missed this item, Lordship. Anyway, I will.
List again showing the name of Mr. SMT Chisti, land counsel for the respondent contaminant.
24, 25, 26.
That is regarding my lord, determination of industry seniority, my lord.
Who appears?
My lord, my friend is my lord, item number my lord, 25.
No, is the service complete? This is a contempt case. No?
Contempt case, my lord, notice has not been issued. My lord.
Contempt notice has not been issued. Which order is violated?
My lord, in this case, my lord, Lordship, may kindly turn to page 28, the opposite part at page 32. My lord.
28.
Order dated 31/3/2023, and operative part page 32. My lord. Second last, my lord, paragraph 12. My lord. Then my lord, Lordship, may kindly turn to page my lord, 34. My lord.
Who is Poesti Chalakura? Nuria. No, he's a teacher. No, who is Alauddin Sheikh?
Alauddin Sheikh is my family. He was the petitioner, and I was the resolution number 6 in that petition.
Alauddin Sheikh, huh?
Yes. My
I understand. You are Abdul Jalil.
Jalil sir.
Who is this contempt petition? Abdul Jalil. Why there is contempt?
Because my lord, the order was state my lord, giving insertion, and it was till my lord 8/5/2023 only.
Sorry?
My lord, that order, Lordship can come to my lord, page 32, paragraph 30.
We have read it. Huh.
Yes, my lord. It was the interim order till 8/5/2023, and on the date, my lord, it ought to be my lord, considered a fresh as per my lord instruction. But thereafter, my lord, the interim order was not my lord, extended. Even then, the my lord, subsequent order was passed by the DG.
Which order?
That is page 34. My lord. And the last my lord, sentence, till the final judgment of the honorable court order. Page 34. My
Huh. State till 8/5/2003. This order is dated 4/5/2003 within the stay order.
Yes, my lord. But my lord, the last line, my own normal duties till the final judgment of the honorable high court's order.
Okay. What is wrong in that?
And
We're dismissing with a cost of 10,000. Heard Mr. D.A. Kayum, Land Counsel for the petitioner also. No, don't invoke contempt jurisdiction so casually.
And I have challenged that
Whatever it is.
in my writ petition.
You could have filed an IA in the writ petition. We have entertained everything.
No,
Not in
I have filed the writ petition, my lord, challenging that what happened.
that we'll do it separately. We're passing this order in a contempt petition. Contempt is not the instrument given by law to browbeat the respondents. It's a very, very serious jurisdiction. Anybody who wrongly invokes contempt also violates the court's order.
By submission before lordship, my lord, that order was, my lord, paragraph 30, it is provided that the extension of the interim order beyond the next date shall be subject to instruction which received by the learned standing council released the matter 1/8/5/2020. My lord understanding is that, my lord, the interim order has to be considered afresh my lord, on the next date, that is 8/5/2023. And my lord, 8/5/2023, the interim order was not considered and it was not extended. My lord. Then, my lord, the my lord, order was the passed on 4/5/2023, holding that, my lord, the petitioner will continue till final judgment of the my lord order.
Very well. So where is the contempt?
Because my lord, it was my lord,
No, we want to pass this order because we have noticed that the contempt jurisdiction is being misused severely nowadays. It's almost being reduced to an execution case, number one. Number two, to browbeat the respondents, the contempt jurisdiction is being used so that if you don't follow me, I'm going to, you are in trouble. I am in contempt. So we want to clarify what is the contempt law, dismiss with cause, so that in future you don't. Sorry, never. Order has to be there. After we decide our order, we will not allow it to withdraw. Heard Mr. D.A. Kayum, Learned Counsel for the petitioner. Also heard for the petitioner. This contempt petition is instituted alleging willful and deliberate violation of the order dated 31/3/2023 in WBC 1792/2023. By the order dated 31/3/2023, in the interim, and having given its reasons, the order impugned therein dated 24/3/2023, allowing the respondent number 6 therein, namely Abdul Jalil Sarkar, from being the in charge headmaster of Poesti Chalakura Nuria Emi Madrasa was stayed. The interim order clearly provides that without obtaining any clarification from the higher authorities, the district elementary education officer Dhubri ought not to have disturbed the position of the writ petitioner therein, that is Alauddin Sheikh. In compliance of the interim order dated 31/3/2023, the in charge district elementary education officer had passed the order dated 4/5/2023 by allowing Alauddin Sheikh, the writ petitioner, to continue as the in charge headmaster of the school. This contempt petition is instituted in the premises that the interim order provided that the order impugned therein dated 24/3/2023 shall remain stayed till the next date of listing. And the next date of listing is ordered to be 8/5/2023. But the district elementary education officer had allowed Alauddin Sheikh to be the in charge principal till the final judgment of the court. A contempt is maintainable upon willful and deliberate violation of an order of the court, and not a mere aberration. Firstly, Mr. D.A. Kayum, learned counsel for the petitioner, submits that the order allowing the writ petitioner to be the in charge principal was beyond the next returnable date fixed in the interim order, but the said statement appears to be incorrect, as the next returnable date is 8/5/2023, where the order allowing the Alauddin Sheikh to be the in charge headmaster is dated 4/5/2023. If the order dated 4/5/2023 had allowed the writ petitioner to remain the in charge headmaster until the final judgment, comma, whereas in the interim order it was provided that the interim order is up to 8/5/2023 and extension thereof would be considered on the next returnable date, comma, the same by itself cannot be held to be an act of willful and deliberate violation of the order of the court. A contempt jurisdiction cannot be allowed to be invoked by any of the aggrieved parties merely on a premises of a slight aberration in their acts, unless it is also shown that the intent and purport of such act is to willfully and deliberately violate the orders of the court. Nor a contempt jurisdiction can be allowed to be invoked merely to achieve the purposes of one of the litigants or the other by making it a sword of Damocles to be hanging over the head of the respondent government authorities, that unless you correct any kind of little aberration, the litigant would invoke the consequences of a contempt jurisdiction, that is, which may ultimately lead to imprisonment of the alleged contemptor. The entire approach of the contempt petitioner appears to be misconceived, and not only misconceived, but also with the purpose of achieving an oblique purpose by invoking the contempt jurisdiction. If any such minor aberration was noticed, the same could have easily be corrected by filing an appropriate interlocutory application in the writ petition itself, rather than invoking the contempt jurisdiction. For misuse of the contempt jurisdiction, contempt petition accordingly stands closed, stands dismissed. However, for the misuse of the contempt jurisdiction, the petitioner to pay a cost of rupees, how much? 5,000. To be paid to the to be paid before the legal aid services for the High Court.
Then my letter 24 and 25 maybe.
There you file IA, will correct it.
But I have filed the repetition, challenging that what happened.
Okay, where is the writ petition? Writ petition will entertain, but not this, don't go in contempt so easily. Where is the writ petition number?
26, that is space 3368.
3361.
26. Item 26.
It is also noticed that against the order dated 4/5/2023, writ petition WPC 3368/2023 had already been instituted by the petitioner, wherein notice was issued on 14/6/2023. But no such interim order was passed. Whereas on the other hand, the contempt petition is filed on 11/9/2023, that is during the pendency of WBC 3368/2023, which gives further credence to the view form that the contempt petition is more in the nature of achieving an oblique purpose, which could not be obtained in WBC 3368/2023. Cost 10,000. Cost is 10,000, not 5,000. Don't do it, please.
On the petition or
Whatever it is. In the writ petition, you submit whatever you have to submit.
Yes, Milord.
Last date is N. Phukan placed for 3 weeks time to file affidavit. What happened?
This Phukan was appearing, we have received instruction, will be filing.
Mr. E. Phukan, Land Council for Elementary, states that the instruction received and the affidavit will be filed within
2 weeks. After the vacation, immediately after the vacation.
Only Milord, Lordship will kindly Milord, see the orders, Milord. Since 31/3/2023, Milord, the matter is delaying, Milord.
31?
31/3, the earlier, that item number 25, Milord. He filed the writ petition.
No, you file an application for hearing or you make your prayer for hearing, we'll hear you. No difficulty. Hearing you is no difficulty. But that doesn't mean you'll invoke the contempt jurisdiction.
No, Kundama, I have no Milord.
Next item.
But my writ petition, since they are delaying the matter since Milord March 2023. And I am Milord.
You make a prayer for early hearing, we'll hear you. Said, I'm suffering because of the interim order, matter be heard, we'll hear you. When do you want? Today?
As
If people are ready, we'll hear you. Are you ready?
Milord, because he has the Milord writ petition.
Don't throw fingers at here and there. That is another form of contempt. Mr. Qayyum. Come down. Come down to logic, come down to hearing, make your arguments, we'll pass your orders. If necessary, we'll vacate the interim order also. Okay.
Lordship, please the matter in.
When do you want?
Next week, Milord.
After the vacation, because I just got my instructions, Milord, I have to file.
That expression is again unacceptable. What did you say just now? He is saying something. Wait. Mr. Qayyum, this is a court of law, mind you. You are not on the street. Your behavior is of utmost importance for us. And the dignity of the court is of the highest consideration for us. Your petty internal quarrel cannot be the guiding factors in a court of law. Do whatever you do outside. Go file FIRs against each other. But don't show it in a court of law. Here only to hear you on the legal issues. That's all. And to be presented in a manner how a learned counsel is required to present. Not those street fights outside. Don't bring it here. Don't reduce the dignity of the court. This court has a very, very high tradition for the last 75 years. And we will not allow you to bring it down under any condition. If necessary, we are ready to take action against you also. Please keep it in mind. Yes. You want some less time, take a little lesser time.
Then 2 weeks, Milord.
2 weeks. This also, so we'll hear you on that day.
My Lord.
We'll hear the entire matter. A fixed date. We give me a fixed date, we'll hear you, all of you come prepared. What is the result of this college? Any idea? Check up. Result of that particular college? Is it something highly exceptional? No, to justify this kind of discipline, is it being converted to a very, very exceptional result?
I do not think so, Lordship. I don't think so, Lordship. I'll including that also regarding the.
Let me do this. Yes, you want to say something?
Prayer, Lordship.
No prayer. Your matter is over.
Yes, Lordship. Fixed on 12, Lordship. 12 and 13, I will be out of session, Lordship.
Okay, you want to change of date? That you take it.
16, Lordship.
No, 16, no. Sorry. Not those 2-3 days before the vacation. Make it before 12. Aji ki maan, teeny. 11. 11?
One is. Okay. I'll inform you. Okay.
Item 27.
Page 35. And the operative question starts at page 37.
Deepak, wait a second. 11.
Para 6 onwards in page 37.
Representation.
Because my lord, my assessment betterment marks were not provided. So there was a direction that you can make it.
Where is Mr. Chisti? Chisti. Hey, this contempt petition, only order is to pass some order in a representation. Why don't you do it instead of issuing contempt notice for this purpose?
I'll take it.
Today, or shall we take it up after some time? Next round.
I'll try to take over from.
We'll call again. See, when we started our profession, contempt cases used to be the rarest of the rare case. And it used to be so rare that whenever there is a contempt, almost everybody takes interest. What will happen today? And in most of the contempt cases resulted in some punishment and contempt trial. Are you aware of the concept contempt trial?
My lord,
Nowadays, those concepts are gone.
only I filed one appeal against the judgment, against the contempt proceeding. Then it was taken up by a division.
No, that is division by single. What is contempt trial? So see the way this jurisdiction is diluted nowadays. People have forgotten what is contempt trial.
My lord. Your lordship has taken the dignity of the High Court, my lord. Taken the consideration of the dignity of the High Court's order. That is why your lordship has said that if the contempt is taken so lightly, everything goes.
No, I'm telling you about 25 years back, whenever there is a contempt petition, almost all the lawyers used to be interested to know in that matter what will happen today, because something is going to happen.
My lord.
Now, if you count the list of all the courts, there may be hundreds of contempt cases listed every day. See
My lord,
how the relevance of a contempt has come down and just changed nowadays. It's almost
Your lordship last order may take some.
it's almost like an execution case nowadays.
Yes.
As if second, and your officers also equally to be blamed.
Yes, proven.
The reports that we have is when a order of the court is placed, after some days, the next question they are going to ask officer, is there any contempt petition? No, throw it away. Officers will take it seriously only when they come to know that there is a contempt petition also now pending. Why don't you change your approach? The way we impose costs, it's time we take up contempt trial of one of these officers very soon and set it as an example that this is what is going to happen to you. This simple innocuous order, dispose of the review. Why don't you do it? What difficulty you have in disposing it? Tell me.
In fact, we always suggest, my lord, these such kind of orders.
Who is the man who is not adhering to your suggestion? Tell me the name.
It is not, my lord. Nowadays, my lord, they have taken up, my lord. Your lordship.
No, you said we are suggesting.
No, we always suggest.
So we respond to that. Tell me the name of one man who is not adhering to your suggestion.
And that suggestion, my lord, in fact, has been taken care of, my lord. recently when many speaking orders has been passed. In those cases, in
Why do we
provincial
have to wait for a contempt to be, orders are passed in a contempt, after contempt, not before?
Different difficulty is, my lord, these orders are not being placed before the authorities on time. Sometimes it is,
No, if it is not placed on time, placed later, you pass your order.
my lord.
If placed after 6 months, I cannot pass any order. Do it. But don't throw away the court's order. That's equally true.
Usually, my lord, the court's orders are also from the date when it is placed before the authority.
But these are not answers, actually. Both.
This
both
has
were-
to be, my lord, anyways, my lord, there is a court's order, my lord, this has to be approved. There
And
is-
see, to the extent that we asked you that what is contempt trial, now people doesn't know what is a contempt trial.
we have
Contempt trial is after issuing notice, after seeing the reply, the court frames contempt charges. From then the contempt trial starts. And whatever punishment is or what it was, it is done after that. See the Contempt Act properly. Those stages are not there anymore. Contempt case, notice, after 2-3 months, complied with,
Compliance.
contempt closed. Is it not a misuse of a provision of a law?
We'll take-
This next item,
28.
I contempt. You want to implead somebody?
My lord,
Whom do you want to implead?
therefore permission, the container number 1 lordship is wrongly recorded lordship.
Wrongly recorded. Who had wrongly recorded?
Inadvertently clerical mistake, lord. From my side. Lord.
Oh,
Lordship,
no.
contempt
You
number
are
one.
filing an IA in contempt case 292.
Dr. Vijay Chaudhary.
292, who are the respondents?
The Narayan Kaur lordship, the contempt number 1 lordship. In my contempt petition lordship.
Narayan Kaur
Yes, Lord.
and Mamata Huzai.
Yes, Lord.
Now whom do you want to implead?
Now, secretary, contempt number 1 lordship. This Dr. Vijay Chaudhary.
Dr. Vijaya Chaudhary is the secretary.
Secretary, Lord.
What about Narayan Kaur?
So, lordship. Narayan Kaur is initially he was a
Okay. When the contempt was fined, Narayan Kaur was the secretary. Now Vijaya Chaudhary is the secretary.
No, it's wrong, Lordship. Nayan Kaur is the present secretary, and Vijay Chaudhary, he was the earlier secretary. Now, because of severe illness, he is no more. He's not coming to the office for last 1 year. Now, Nayan Kaur, he's holding the charge of. Yes, he's the secretary.
I'm extremely sorry for that, Lordship. So my
He's confused the other way, Lord.
My eye is infectious, Lordship. I may allow to take his eye, Lordship. So one of my colleagues.
Mr. Hasi Das, when Council Petition states that no order is required to pass in this into the application, in view of such statement, IA stands closed.
Yes, Lord.
Liberty granted to approach again if so advised.
Yeah, and Lordship, I'll take the press step.
Upon?
Press step against the container number.
Which
One and two.
content?
Step, Lordship.
Otherwise, his complaints are all right. Nayan Kaur and Mamta Hozai, they are all right.
Where do, in which case you want to take steps? IA?
No, main petition.
Main, upon whom?
So container number 1 and 2, Lordship.
You have not taken steps.
Initially, I have taken a step, Lordship,
You
but
want-
they did not reply, Lordship.
Not served or what?
I have served, Lordship. 2 times registered, Lordship.
No. You have notice is served or not. You have only taken steps. To date, neither AD card nor answer notice have been received back.
Last petition, Lordship, I have taken a step, Lordship. 2 times I have taken a step, Lordship.
Nayan Kaur IAS, ACI, not IAS. Certificate of Government of Assam, become the ভালকে লিখব লাগিব কি কি লিখব
How many times will you take steps? These are government officers.
Yes,
Where is their office?
In the respondent one is in Secretary Lordship.
And then other one?
Other one is a Kahilipara Director of Office Lordship.
Why the postal department cannot serve them? First steps were taken on 5/6, no AD card, nothing. Then next set 24/8, fresh notice issued. Again, no AD card, nothing. Now he wants to take steps for the third time. Why should we be at the mercy of the postal department?
Let me submit copy. I will
Issue. Who is the head of this postal department here?
ये Postmaster General will be there. Chief Postmaster General.
What's the name? Find out. We have found a case, Deputy Commissioner address is not found sometime back.
Yes.
Now, no AD card, nothing is coming back. Why? Why should he take test for the third time now? Just check up, give me a copy. Is the address right or wrong? Please check up. Give me a copy to him.
Address is right, but he is not properly written. Narayanpur is between IAS, Secretary of Government of Assam, Department of School Education, Secondary. So some spelling mistakes were there only. This session he is also. And Mamata Hozai is and he has written Hazoi.
The petitioner to correct names and addresses of the respondent condemners for
and in Costa
proper service of notice.
And he has written K19. This is still proper from in Kamrup.
You correct.
Anyway.
29 for hearing.
By filing an interlocutory application. Bring everything correct, name, address, so that the notice can go. Otherwise,
These pages, Your Lordship. Lordship, before starting the matter, I'd like to pray for a
2013 matter.
Yes, Lordship. I'd like to pray for a little accommodation, Lordship. I'm being led by my senior in this case, and he is out of town because of some personal exigency. Lordship, in case I need his guidance, Lordship may kindly keep it as part heard.
Sorry.
In case I require his guidance, Lordship may kindly keep it as part heard.
You are ready to argue the matter?
Yes, Lordship. I
Very
place
well.
the facts.
Lordship,
Very well.
Before my colleague starts, Lordship,
Anything other than adjournment?
other than that, I just want to point out one thing. In this matter, Lordship, already group of batch of cases have been passed regarding the old pension scheme by my Lord coordinate bench, Lordship. And my Lord, here, Lordship, the finance department also will be required for clarification. My Lord,
What is the issue?
Lordship, we are seeking
We haven't
coverage
made
under
them a
the
party.
old pension scheme, Lordship.
You want to go back to the old pension scheme?
Yes, Lordship, actually, we were originally appointed in 1999.
No. According to you, under the law, you are entitled to the old pension
Yes,
scheme, not the NPS.
No.
Okay. Why? You
Lordship,
appointed in?
1999, Lordship.
Hmm.
Lordship, there was
Where
a-
is the appointment order?
Lordship may find the 24 page number.
24.
At page number 25, Lordship may see the date 2011-99.
And a person passed out the junior basic course.
Yes, Lordship.
Where is that?
Lordship, at page number 24, Lordship may see that
20. Oh no, we have seen the appointment. Appointment is conditional, having undergoing basic training course.
Yes, Lordship.
Have you successfully undertaken the basic training course?
Lordship, to my instructions, they have undergone it, but
Do you have the result or certificate or mark sheet of the basic training?
Lordship, that I do not
Please produce it.
Lordship. Lordship, actually what happened in the meanwhile is that there was another select list based on the same advertisement. And on the basis of that, certain people were appointed during the same period of time. And while the petitioners were working, and because of that, their salaries and everything was stopped for a period of 10 years, Lordship. Due to the grievance that they were not being paid any salaries and everything, they preferred a representation, but after that nothing happened and they preferred a writ petition, and they were asked to go back to the civil court, but instead they preferred a writ appeal, whereby the petitioners were the matter was reverted to the commissioner and secretary. They were asked to take
Where is the writ appellate order?
Lordship, at page number 60.
60.
Yes. Lordship, may find the relevant part at page number 61.
Referred back to the state order. Identical matters disposed of in WS so and so 15 to 2008. Where is 15 to 2008?
71.
Identical.
Page number 71.
71.
Third parallel.
This is WF 418.
Yes. It is 418.
418 or 481?
It is 418, Lordship. It is wrongly typed.
Page 71 is wrongly typed.
Yes, Lord.
It should be 418.
Yes, Lord.
Now, what is those other writ appeal order?
It's the same order that it has been.
No, 21/7/2007 and 28/3/2007. We are inclined to pass the same order.
Yes, Lord.
So that is the original order. How does it read?
Lordship, may find that order at page number 77, Lordship.
77.
29.
This is also again. See, this is the fourth generation covered case.
Lordship, may find.
Where is the original determination by the court?
Lordship, at page number 59, Lordship.
59.
59. This is,
See, 60 follows
60
page
is the-
71, 71 follows page 77,
Lord-
77 again follows something else.
Lordship,
So where is the original determination?
the order of the
Madam,
writ
in
appeal, Lordship, that we have filed.
Simple words, we would like to know in what manner your claim was determined by the division bench. So what kind of legal right can flow in your favor now? 58 is the original.
Lordship, at page number 61, it is being referred. When the
Hmm.
matter is taken up for admission hearing, learned
It's also
counsel for the
noted,
third parties submit that identical orders have already been passed, disposed of by this court by order dated 15 to 2008 in writ appeal number 418, Lordship, that I was referring to. That is at page number 78, Lordship. Writ appeal original 418.
Yeah. 86.
78.
So page 59, go to civil court.
Yes, Lordship.
After that, what happened?
We prefer.
No. come to page 77. It is stated at bar that the issue raised in this appeal was heard and decided by the division bench in Shamal Datta and Hassan Bak Chaudhary. This petition is Hassan Bak Chaudhary. Disposed of on 28/3/2007 in miscase, wherein some inadvertent typographical mistakes occurred in the order were corrected. Having regard to the order dated 29/1 and 28/3 passed in WA 9 of 2007 and 111 of respectively, also we are inclined to dispose of this appeal, holding that the order direction given above be also applicable to the instant case. Now, where is that original order? 29/1/2007 and 28/3/2007.
That is probably not.
You have to bring it. Because 77 follows that, 71 follows 77, 61 follows 71, and everywhere it is stated that that decision will also be applicable. But we don't know what is that decision.
Lordship, at page number.
The petitioners to produce the orders dated 29/1/2007 and 28/3/2007 respectively in WA 9 of 2007 and WA 117 of 2007. Inasmuch as all the division bench orders referred ultimately leads to a situation where the aforesaid two orders had been held to have been followed. List on.
Just wanted to point out one more thing. Lordship, they haven't made pension and the finance department a party also. But perhaps they will also be required because in the previous.
Why are you required to hear pension and finance?
Pension, my lord, because of the fact that the old pension scheme, my lord,
Doesn't matter.
other cases, my lord, everywhere. they
Their
made a
claim is we were appointed sometime in that 99. On being selected by the district selection committee or something.
My lord.
Then the situation came that two lists appeared.
My lord.
One by which a petitioner is appointed, another by somebody else appointed. In this situation, petitioners not paid salary for 10 years. They approaches the court. Ultimately leads to these two orders of the division bench, which have been followed. Let us see what is that order. If their legal right of having appointed in 99 has been recognized, they will be covered by the old pension scheme, not by the NPS.
But they have
We
given.
don't need the
but they have
finance
signed,
department for
my
that.
lord, in 2009. In 2009, they have, I think, signed an undertaking also when they joined again.
You are undertaking
Because they have signed an
when
undertaking. pension,
the might of the state imposes a condition,
My lord.
these people have no other option other to sign,
My lord.
take whatever is given, and then continue with the agitation. Otherwise, they will be in the streets.
Perhaps,
Without
my
signing, he
lord,
will not even pay their salary.
That is true, my lord. But perhaps they will be
And
a necessary party, my lord.
these undertakings have almost has no effect in law.
Lordship, we were found to be genuine by the order passed by the
Only
Commissioner and Secretary.
question to be determined is whether they were actually appointed in 1999 by following the due procedure of law. If appointed, they are in the old pension scheme. If not appointed, you seek to reappoint them subsequently, then a new pension scheme. This is what we are determining.
My lord.
And ultimately, it is the education department who will tell us whether they are initially appointed or not. We don't need the finance and pension for that.
My lord.
30, 31, 32.
Sorry.
We got the name of the postmaster general. His name is Subrata Rasme.
No, there are some address is wrongly spelled out. So we pass the order. But tell the postmaster in one of these cases, we are going to issue contempt on him.
I can convey it.
We don't understand why the postman cannot go and serve a government officer, the secretary to a department in Dispur. Why he cannot be
Crucial
served?
issue, my lord. I'll inform them.
Looking around for a private person in an odd village is a different. You may not locate him. But why these deputy commissioners, secretaries, these authorities cannot be served? There's no reason.
It is. So item number
It will
30 to 52, my lord.
Hmm.
These matters have become infructuous in light of a division bench judgment.
Infructuous.
Fazaluddin judgment.
Will not record anything. But does your name originally appear?
My name is 30.
Sorry. Two 2084.
And what has happened is the judgment was passed in the matters which are before your lordship today. Then against that judgment, a review was preferred. That review order says that the matters are to be reheard. Against that review judgment, Fazaluddin went into appeal before the division bench. The honorable division bench passed an order
So,
allowing the appeal under
so this review is against my order.
No, my lord, what happened in the division bench? Division bench
No.
was
Understand.
allowed.
Mr. Verdwas, this is a review petition?
No,
It's a writ petition.
These are writ petitions. Against these writ petitions, a review against the judgment passed in these writ petitions, a review was preferred. The review order said
Review says it has to be reheard.
reheard.
And the party agreed when it writ appeal.
Yes.
And
The
it
writ appeal
writ-
was allowed. That order have placed before your lordship.
The review order has been set aside.
Yes.
So that means
That part, my lord, that small part from the language itself, your lordship will find that the writ appeal was allowed. But that small part, what to happen of the review judgment, my lord, it was kept silent. And that's why these writ petitions are again discussed.
where is it?
But to my humble understanding, my lord,
Whose order? My order. Okay, I'll give a meaning to it.
my lord,
In view of the above order, view that instead of making an attempt to decide the seniority aspect between the appellant and respondent.
paragraph 10 onward.
We'll see that the review order merges with the writ appellate order. Review order goes.
Yes.
Once the review order goes,
The writ appeal, these writ petitions.
the writ petition also goes. Everything goes.
Lordship, after the writ appeal, an order was passed and we have preferred another writ petition.
That will remain.
That is independent.
That will remain. You will hear that. Heard Mr. P. Bardwaz and counsel for the petitioner. Do we appear in the other writ petitions?
No, my lord,
Who
other writ
appears?
petitions and for the respondent.
No, item number 30. Who appears?
31 and 32, I am the petitioner.
Oh. Fazaluddin and Dildar, these are the two contesting parties. You represent Fazaluddin. You represent Dildar. WBC 8084 went in your favor.
My lord,
It's
the
2084.
review was filed by me, my lord.
No. In WPC 802084, in whose favor the order was passed?
And it was against me.
Against you, against Dildar.
Yes.
So Dildar filed review.
Review. And Fazal filed
Just a minute. And review said matter has to be heard again. Then against the review order, Fazal went in writ appeal. Writ appeal, a totally different view was taken. Go by the 2017 Act. We are not deciding the 2015. So this is 2084. Now what is 5757?
It was dismissed as infructuous by the order.
So that is already gone. We
At
don't
that
have to
point of
pass.
time, it was
We
gone.
don't have to pass any order in that. That's already closed.
But later on, probably it was opened in the review. It was open in the review.
It was again open.
Yes, all the
5757 also
all the
open.
repetitions were open because Lordship,
Okay.
the common judgment was passed. The order
judgment
dated
was
was
Understand. And 7496 2013 by
It was allowed.
Fazaluddin?
It was allowed.
Allowed.
Yes.
Then what happened to that judgment?
Then they preferred the review petition. The entire three writ petitions were decided by one common judgment, and after
So ultimately, a single judge went against Dildar in favor of Fazal.
Yes.
Okay, Dildar preferred review. It says issue requires to be reopened. Fazal goes in writ appeal. A totally different order was passed. Mr. P. Bhardwaj and counsel for the petitioner in WPC 2084-2014 and MS
N Begum.
M
N.
and
Last name Begum. N. N for New Zealand. New
understand
Delhi.
New Zealand. Then after that,
New Delhi Lordship. Begum.
Begum, and that's what we have. And MS and Begum for the petitioner in for the writ petitioner Muhammad Dilbar Hussain in WPC 2084. You've heard was, and Begum for the writ petitioner Muhammad Fazaluddin in WPC 5757 2012 and 7496 2013. The dispute between Muhammad Dilbar Hussain and Muhammad Fazal Hussain is regarding the provincialization under the Act of 2011 as in a post of
Assistant teacher.
assistant teacher in school number
Sutargaon Public High School.
in
Sutargaon Public High School.
Sutargaon Public High School. WPC 2084-2014 was decided against Muhammad Dilbar Hussain, whereas WPC 7496-2013 was decided in favor of Muhammad Fazaluddin, both by a common judgment and order dated
23/4/2015.
23/4/2015. Whereas WBC 5757-2012 was closed on the ground of being infractuous. Against the judgment to date to this 15 or against the judgment dated so and so, Muhammad Dilbar Hussain instituted a review petition
76/2015.
76/2015, wherein the order dated
6/3/2017. 6/3/2017.
6/3/2017 was passed, by which a conclusion was arrived that the issue requires to be reopened. Being agreed by the judgment dated 2017 in review petition so and so, Muhammad Fazaluddin instituted WPC WA 65/2018, which was given a final consideration by the judgment and order dated 23/7/2018, wherein in paragraph 18 it was provided as extracted. As per the writ appellate order dated so and so, the issue of provincialization between Muhammad Dilbar Hussain and Muhammad Fazaluddin would now be determined under the Act of 2017, Provincialization Act. As the original dispute between Muhammad Dilbar Hussain and Muhammad Fazaluddin was as to who between the two is to be provincialized under the Act of 2011, and the division bench in the writ appeal having arrived at a conclusion that it would now be determined under the Act of 2000, and respective claims would now be determined under the Act of 2017, a view can be formed that the writ appellate judgment order dated so and so in WS so and so would prevail over the order dated so and so in review petition so and so, as well as the order dated so and so in WPC Iman and Iman. With the above clarification, WPC 2084-2014 and WPC 7496-2013 are answered accordingly. The parties shall now be governed by the judgment and order dated so and so in WA so and so. It MSN Fukan learned, MSN Begum learned counsel for the petitioner for the Muhammad Fazaluddin has made a statement that the resultant order thereof had also been assailed by Muhammad Fazaluddin in WPC
7105 of
7105 of
2021.
2021. The said writ petition would be decided on its own merit. In the WPC one would be said na lage, 2021 or writ petition would be decided on its own merit.
I'm just pointing out, in the cause list, item number 5757, WPC 575 has not been shown as disposed. It might again get listed.
To dispose. Massage.
Well, what does the actual order sheet show? Not the cause list. Cause list cannot prevail over the actual order. It would Mr. Madhvas, take a look at the original file. If it is not so, we'll change that line.
Five seven.
Now get asked again.
Item 33.
33, you can there. No, 5757 যদি আগে বন্ধ হোৱা নাই বেলেগ এটা লাইন লিখিব has been এটা ইনফ্ৰাষ্ট্ৰাকচাৰ বুলি যে ক'লো আগতে it is stated by in the meantime has become infractions accordingly closed. 5757 বেলেগ কে দি দিব
Petitions before my lord are lecturers in politics, in non-technical subjects, maths, English, social science. Historically, they have been paid under the UGC scale. The rules under the Assam Education Service. All of a sudden, my lord, the finance department says, no, you will now be governed by the AICP pay scale. I have been given the AICP, which is a slightly lower for the lecturers, and we will not get designations like assistant professor, associate professor. It was in 2010 that they did it. Subsequent RTIs from the education department clearly shows that we are governed by the UGC scale of pay. The rules that have been amended in 2020, my lord, says that we are under UGC. We are under the AES service. Now we are being tried to be brought under the Assam Technical Education Service, which is, my lord,
AES means Assam
Education Service.
Education Service.
Because, my lord, we were recruited along with teachers in Cotton College, DIFU, all way under one recruitment. My lord. We got bifurcated because of our merit positions. Now they are assistant professors, associate professors. We are still lecturer, senior grade, lecturer, my lord, selection grade. And, my lord, the scale of pay in 2010 was put slightly lower. They were given 6,000, we were given 5,400.
So we understood.
That's the issue.
No, we understood. These people are teachers in maths and other allied and not on those technical subjects. They were recruited along with some other similar teachers in many other institutes. All those institutes are governed by UGC scale. And in the part of the same recruitment process on the by virtue of your merit position, you are in this technical institute. Otherwise, you would have been in the other one.
Gradation list was
Very
same.
well.
Gradation list was same.
Understand.
But, my lord, subsequently there was an amendment by which engineering college, non-technical, and, my lord, politics was made one, and the other colleges were different.
No, so you want to be governed by UGC now.
UGC.
So you are entitled to UGC.
UGC. Education department says UGC.
Very well. Education, which department?
Higher education. Higher technical education. RTI replies are there.
Education technical or education higher simply?
Technical education.
Technical.
Like technical.
So if they said, then what is your difficulty now? Why are you before the court? then?
Because, my lord, I'm not getting the designation of assistant professor, associate professor.
Who is not giving?
The authorities are not giving.
Higher education.
Higher education, because the finance is objecting. Finance says you are now under the technical department.
So now we to hear finance or a higher education?
Both, my lord. My lord will have my
Where
friend first.
is finance department?
Oh, my lord can, this was with 2010. If they can also bring on, my lord, subsequently what, because I have somehow lost touch with this class. Maybe they have gone also, my lord. They retired and all also.
Gone means where?
Retired, my lord, gone from service, my lord. Not gone from the world, my lord. They have, because the numbers that I had, if they can also bring on record, my lord, because there were 2 revisions thereafter, my lord. Or at least one, my lord. 2016 there was one. If they can bring that also.
No, we are not thinking on that one. What we are thinking, you will not like it.
No, my lord, still, my lord think I'll have to accept.
No, you may not like it.
Well,
You
that's
accept is
different thing,
different thing, but you will not like it.
What is it?
We understand through a general recruitment process, depending on the merit position, these people are in a technical institute. Had it been higher, they would have been in a general institute, they would have got a UGC scale. UGC scale is slightly higher than the AICTE scale.
And the designation.
Now, the technical people of that same technical institute, they are getting the AICTE scale. Suppose if we can bring about an equivalence between these category of teachers in the non-technical subject and those teachers in the technical subject, why will and that too in a technical institute, why will the non-technical man get a little higher than the technical man?
No, with the technical man, they are also getting a lower, 5,400 starting there. Whereas, my lord, AGP.
No, we are not on that.
We both are getting same, my lord.
Who?
Technical, non-technical in technical institute are getting the same scale.
But you want the higher one.
I want, my lord, 6,000.
No. Now, within the institute, will it not be a disparity?
Because, my
if
lord,
the
historically, this was done, my lord.
But
Historically, it was done.
But history doesn't determine Article 14.
But, my lord, that nobody has come up before, my lord, with a challenge.
But
because my roots,
Mr. Nair, but you expect an order from us. And before giving an order, we have to be very, we are required to look into the
my lord,
question.
in 2009, there was an amendment by which the general government colleges were separated to a different cadre and engineering colleges and polytechnics were made one cadre, non-technical, under the AES rules. We have not been taken away from the AES rules.
But otherwise, suppose I am a teacher in a technical side. You are a teacher in the non-technical side.
Lordship.
Both of us otherwise in the
same institution,
same level, everything.
Lordship.
Just because of the historical situation and the manner in which you are recruited, you'll be getting higher and I'll be getting lower.
That's true. Otherwise,
here, by virtue of the historical background and by virtue of the manner in which I was recruited,
Lordship.
Can there be a reasonable classification between this technical and the non-technical teachers?
Because, my lord, this non-technical and technical were never amalgamated.
See, there is one judgment I know
Lordship.
for creating a reasonable classification.
Lordship.
Historical factors are also relevant.
Lordship.
But that is a totally different history, not this recruitment history. That is a historical factor. Historically, a particular community or somebody is subjected to some disadvantage, somebody is not. You maintain a reasonable classification.
Lordship.
That Supreme Court has justified.
Lordship. I'll
but
just...
it's there. If you want, I can give it a
I'll get it.
It's something of the 1970s or
I'll get it.
But can the method of recruitment
and the service rules, different service rules were there. Now they are trying to amalgamate
also be a historical aspect? I don't know.
I have not thought on that line, my lord. I think I'll have to work on that line.
I think
I'll do that.
we'll have to answer that.
No,
actually.
Lordship
Not
will
only that,
Lordship will have to.
means
have to.
we don't take
No, my lord will not take a half
excitement
measure.
in raising questions.
My lord will not take a half measure. My lord
But
will-
the difficulty is we are bound to answer it.
Lordship will have to. I'll try to assist your lordship. But only thing, my lord, if my friend can also get on record or just an instruction.
We'll
a
continue to ask the
subsequent-
finance department to come.
My lord, can it be next week, my lord? Some difficulty taken up. my lord.
Did you? Okay, buddy. On the prayer of better did you? Okay.
18, 19, 490.
I think we have to answer, our answer has to
We'll have to
go into that question
Lordship will have
also. Your case, I understand.
Lordship.
You have made out a very good case that this is my method of recruitment, this is that. But again, between you and others who were appointed in a non-technical institute, there may be a reasonable classification by virtue of your merit position.
I did not go into that. I'll have
By
to go into
virtue of you are not in the same
No,
class.
maybe not.
That is there.
But at the same time, comparing yourself in the institute with a technical professor, both in the same rank, he will get less, I'll get something more.
That I did not accept.
What is the?
I'll do that. I'll do that. I'll try to assist, but not give my thing on that. I'll do that. I got what my lord is thinking of. There has to be two answers from my side. One, that first one, and second one, this is more important. Can there be a disparity in the same
Because the
institute?
technical man, everything is same, but because of
The method of recruitment. I'll do that.
actually, firstly, you should not have made it one recruitment. You made a mistake there. Or initially, there ought to have been two different recruitments.
Two different equipment is there. Polytechnic, technical, lordship and non-technical.
Non-technical polytechnic and the recruitment in the non-technical colleges ought to have been different.
Not clubbed together. In this case, it was not.
It ought to have been different, I think.
Originally, but
Subsequently, it was there was something, but earlier it was club. When I was recruited, it was club. I have the appointment order with me. Cotton College.
Mr. Naik,
before
he
law
made a
college.
categorical statement. We believe him.
No, I am not saying that.
Yes, Mr. Soman.
Sorry to disturb your lordship. The next series of items is fixed for hearing. In item number 35, we filed it on behalf of the UGC. We filed an affidavit in the month of May, 15th of May 2023. But somehow, for some reason, it's not on the record.
You want to call for it?
My lord, it was filed in the.
You want to call for it? Did you?
My lord,
We'll call for it. Give the date and the filing number, we'll get it.
All right, I'll come back to the next day. About it.
Technique beside you.
Oh, it's a question.
Even my senior expressed that the affidavit, he requires some time to go to the affidavit.
there is a problem in the, I suppose, in the filing department. It was filed in the month of May 2023. It's lying there. And my friend is also saying that they are not getting a copy. Might be lying somewhere. I'll give you a copy right now, no issue. Miller.
Cover level. Cover level. It just lunch.
Well, you want some other date?
Because they also having to go through.
John on the payroll department. We will list it on whatever date you want. In the meantime, you sort out all this.
Why not? I will give him a copy.
Copies, finding out, getting.
I apologize because it's unintentional
No,
because.
it doesn't matter.
The date on reopening.
37 for orders.
Yes.
Please, Your Lordship. Your Lordship, as per office note, I submit the amended cost title.
Sorry.
As per office note, sir, Your Lordship, I have to submit the amended cost title.
Amended cost title. You have amended your petition.
Yes.
Why?
There was an error in the name of the petitioner.
Yes, Mr. Saikia. That balance period, you have filed some writ appeal.
I thought the state has filed writ appeal, but no stay is there.
What happened to the writ appeal?
And only notice is no stay in there. Continuation petition.
Then we followed a single judge for the time being. And you have amended the cost title.
Yes.
So now,
Order may be passed.
for what?
The finally dispose of the material of petition. I have prepared the cost title, and when in the registry, they suggested me that it will be done later on as well.
Then how can we do it past a final order if you want to change your petition?
You have to file. Otherwise, a short date may be given.
Your name, please?
R.M. Mazumdar.
R.A. Majumdar.
Yes.
Adjourn on the prayer of R.A. Majumdar, in as much as the petitioner seeks to amend the cost title, which is pending before the registry, be listed after the amendment is be listed again.
38.
I for what purpose?
Lordship, for correction of the cost title, Your Lordship. Response number 1 is wrongly typed in the petition, Your Lordship.
Cost title where?
In purchase name, Your Lordship.
Where? In which page?
Page number 6, Your Lordship.
My lord, concerned department will be elementary education, but they have made in second higher education.
Instead of higher.
Higher, my
No,
lord.
no.
B.Ed college, my lord.
Yes, Your Lordship.
Elementary.
Instead of elementary, it should be higher, or instead of higher.
Instead of higher, my lord, it will be elementary.
First, you,
No, Your Lordship, I am made
Mr. Saikia and Madam Dekha, you first settle amongst yourself. She is saying something, you are saying something. When you say something, Madam says no, and when Madam says something, you say no.
Page number 11, Your Lordship, prayer portion, Your Lordship. May I read, Your Lordship?
Page number, no. I am taken out the main writ petition.
Yes, Your
Which respondent you want to change?
Respondent number 1, Your Lordship.
Respondent number
Respondent
1.
number 1, I have made party, State of Assam represented by Commissioner and Secretary to the Government of Assam, Education Elementary Department, District Guwahati 6, Your Lordship. Instead of that, Your Lordship, it should be Additional Chief Secretary, Higher Education Department, District Guwahati 6, Your Lordship.
Yet college is under the jurisdiction of elementary education. It should be elementary. Yet college is any teachers training college is under the elementary education jurisdiction. Even government teachers training college is also.
MSR Deccan and Council for the applicant seeks to amend the course title in WPC 5089-2023 by replacing the State of Assam represented by the Commission Secretary to the Government of Assam in the Elementary Education Department to that of the State of Assam represented by the Additional Chief Secretary to the Government of Assam in the Higher Education Department. But Mr. K. Gogoi, Land Council appearing for the Higher Education Department, has raised an objection that the subject matter in the writ petition involves a BT college, B.Ed college, and that a B.Ed college is governed by the Elementary Education Department and not the Higher Education
Another
Department.
SCRT department.
In the circumstance, an adjournment is sought for to examine the matter. List on switch.
39.
Yes, Mr.
Lordship, as per office note dated 29/9/2023, the AD card has yet not returned in respect of my lord,
It's 5 and 6.
5 and 6. And eventually, my lord, notice has already served, my lord.
By?
But so far my instruction from the petitioner is also the employee of the college. But
The verbal instruction does not lead to service of notice. Where is the?
But my lord, postal consignment also not reflected the detail.
Then what to do? Go and serve Dusty. If you have internal connection, whether the respondent received notice or not,
Dusty,
I think Dusty will be more easier for you. The petitioner allowed to effect Dusty service on respondent 5 and 6 through the registry of the registry and thereafter file affidavit.
I love
40 and 41. Two weeks.
Maybe.
Yes.
Milord, in this case, Milord, I was supposed to take steps, Milord, in respect of respondent number 3 to 6, Milord. But that, Milord, there is a mistake in the post title page of respondent number, Milord, 6, Milord. Sorry, respondent number 5, Milord. I have to correct the name.
Achha, you want to take steps on respondents number?
3 to 6.
3 to 6. And the order says only 3 to 5.
No, Milord, I have
Do one thing, you take steps on 3 to 5 as ordered earlier. Now we allow you to take steps on 6 also.
No, Milord. There is a correction with regard to the name of respondent number 5. Because his correct name is Mubarak Ahmed, Milord. Instead of that, it has been written as Mubarak Hussain
Where did you write it?
in the petition itself.
Then you file an amendment petition, correction petition. How can I do it orally?
So I'll do.
Which respondent?
Respondent number 5.
5. Your name, A. Ali.
A. Ali.
Mr. A. Ali, learned counsel for the petitioner, seeks to file appropriate application for correcting the name of the respondent number 5.
Obliged.
Mr. Gay.
Time being 7 and 8.
Lordship, I don't want to waste your time. Lordship, Council Bigu is on legs. There's a Parkwood Metro 2014 going on in Pakam 10.
Who is the counsel?
Lordship, Council Bigu is only handling
B. Gogoi. It's stated that Mr. B. Gogoi is having some inconvenience today. List counsel.
9 and 10.
May I please?
9, 10. You appear in both the writ petitions. Can we hear it? Can we hear it today? Yes, Mr. Sharma, can we hear it today?
My lord, I'm sorry if I
No, no, forget about the past.
Yes, my lord.
At present, can we hear it today?
my lord.
Okay.
My lord, the government was asked to produce a record or by this honorable court on 1/6/2023. My lord, let me just see that record. If the record is there, then we'll.
Do you have the records with you?
So, yes,
See, once we begin, no adjournment. And if you, for any reason, it cannot be completed today, then you take adjournment.
No, my lord.
We can, okay.
Lordship, the matter relates to selection and appointment to the post of principal, your lordship.
For whom do you appear, Mr. Sharma?
I
Mr.
appear
S.B.
for
Sharma?
respondent number 6, my lord.
Who is he?
My lord, the private respondent. The
Private respondent, okay.
Beneficiary of the selection.
It's for appointment of a principal
Principal.
in a higher secondary school.
Higher secondary school.
6 has been appointed.
He was appointed.
You assailed that order.
Excellent. Basically, my ground is two, your lordship. First is your lordship that the marks he was given the head of experience, your lordship, as in charge principal, that should not have been granted to him 2 marks. And
Where is that? Which page?
that is, your lordship will get the page
30.
36, your lordship. That is the comparative statement of mark.
36. Petitioner is Gangadhar and respondent number 6
is Jayanto.
Jayanto.
Column number 20, your lordship.
Column number 20, yes.
Experience as in charge, that is 2 marks.
Experience as in charge principal, 1 mark for each year.
2 marks.
Hmm.
And your lordship, I was awarded no marks, your lordship. I am not entitled since I was not holding any post of in charge principal.
So total with the 2 marks, Jayanta Varman becomes 18.
Sure.
And Gangadhar Varman is 16. So if 2 marks is taken away, both will be 16.
And then your lordship, in the category of ACR, your lordship, I
Column.
was not, that
Column.
is column 12.
Well, so
No marks are awarded.
dispute is regarding 12 and 20. No?
20, and also I have raised one, your lordship, regarding 10 state awards, national awards. I say that I am entitled to.
You got some award.
Lords.
ACR for last 2 years preceding the year of selection.
Lord.
Good act number, very good, and above
2 marks.
So he was given 2.
2, and I say that I am at least entitled to 1.
Okay, his 2 will remain. But the petition was based on which page? Where is the ACR?
Lordship. Now,
First tell us preceding year of selection. What is the year of selection?
That is your lordship. The advertisement is your lordship.
No, the year of selection.
This 2018. December 2018 advertisement was issued.
And when the selection took place?
Selection took place on your lordship 3/1/2019.
Year of selection advertisement is?
Advertisement is December 2018. And selection took place on 3/1/2019.
December 18 selection
3/1/2019.
1/19. Yes, Mr. U. Sharma. What do you mean by year of selection? Advertisement or the actual selection?
It was, my lord, advertised.
They have probably.
My lord, and all the interview were based on the office memorandum, my lord. Office memorandum of 26 December 2018.
Mr. Sharma, I think we have put a question to you. What do you mean by the year of selection? The year of the advertisement or year when the actual selection takes place?
My lord, interview process was 3/1/2019, my lord.
We know, Mr.
An advertisement published on December 2018.
We are aware of it. So now year of selection will be the date of advertisement or the date of the selection? We are asking you because they are two different years. And ACR has to be preceding the year of selection. So if the year of selection is 19, then it is for 17 and 18. If the year of selection is 18, then it is 17 and 16 and 17. Because his case is he should get 1 mark.
Yeah.
So now we'll examine the ACR of which year? 16, 17 or 18, 19? 17, 18.
16, 17, 18.
16, 17. Have you uniformly taken it for all the candidates or some candidate here and some candidate there?
17, 18. Sorry, 17, 18.
17, 18.
Yes.
So that means year of selection is 2019.
Yes.
Very well. So let me see Mr. Botagu's client's ACR.
One aspect is there, Your Lordship, I just point out. The ground on which they have not awarded marks in this, Your Lordship, is that for the year 2017 and 18, there are 2 different sets of ACR recorded and signed in the name of Gangadhar Varman. It is not acceptable in the eyes of law. Now, Your Lordship, ACRs remains in the custody of the authorities, Your Lordship, as per confidential role, Your Lordship, rule.
Now, Who is the authority who writes the ACR?
Lordship, initially it will be the principal, then it will be reviewing authority will be the inspector of schools.
Inspector. Who appears for the principal? Why did you write two ACRs? You cannot spoil a career of a person by writing two ACRs if not permissible. Let us see the ACR.
Yes.
Let us see both the ACR.
Yes. There's all the
No, don't
candidates
give me
here.
the whole bunch. Take it out. Where is that reason? You said 2 years ACR so rejected. Page number.
Page 41, your lordship may kindly. The
Page.
first order by which
Page 41.
my page 41. Last but one paragraph. These are the grounds, your lordship, on which I was not confident.
Okay, moreover, for that there are two different sets of
ACR recorded and signed in the name of Gangadhar Burman.
Let us see the two sets of ACR.
Yes, ma'am. All these documents are tagged with in a single.
No, at least the
Yes.
flag mark or open it, Mr. Sharma. How do you expect us to go through 50 papers and then find out one relevant paper?
This one is ACR, ma'am.
Take out both the ACRs, two sets of ACR, you say. Everybody is a Burman in this place.
Lordship.
The two candidates are Burman, the principal is Burman. And where is the second set? Where is the second set?
Here, my lord.
No, this is one set.
Yes. Gangadhar Burman is there, and also another candidates also there, my lord.
Mr. Sharma, difficulty with you, you never listen to the question. You always say something, whatever you want to say. How can we proceed in this manner?
Sorry, ma'am.
Your commissioner and all rights for the year 17 and 18, there are two different sets of ACR.
Yes,
We have noticed one set of ACR. Where is the other set?
One set of ACR is there, and my lord, another set is in the writ petition, and my lord, another set is my lord, additional affidavit filed by the.
In the record, we don't want additional and written on. In the record, where are two sets?
In the records, that is only one set.
Then how can your selection committee know that in future there will be a writ petition? In writ petition, he'll set one. In that writ petition, future writ petition, government will make another affidavit. How the selection committee knew the future?
In the record, one set is there, man.
If the record one set, that is one set. How can there be two sets? That means the selection committee is taking note of extraneous materials. How can you give a reply to his case? It's between him and the government. Why should they take the help of a private respondent for that purpose? You are only a incidental beneficiary. You are not even a necessary party for this issue. Yes, Mr. U. Sharma, you have to tell us. Further, school selection committee in its meeting held on this submission of doubtful ACR. What is the meaning of a expression doubtful ACR? Yet fraudulent, committed some fraud.
Maybe, my lord.
Huh? Because the ACR is signed by the principal.
Yeah.
So the principal must have committed the fraud. And where about his 2 marks you were
Lordship,
saying something?
his experience, your lordship.
Experience as in charge, 2
Your
marks.
lordship will kindly come to page 37.
37.
This is the date, your lordship, 31st December 2018. On this date, he was appointed as in charge principal, your lord. Now, from 31 December 2018 to 3/1/2019 till interview, there, even assuming he has taken over charge on 31st, only 4 days of services and in charge headmaster, principal, your lord. And
Yes.
for that, they were given 2 marks.
Yes, Mr. Yusuf.
My lord, in the office memorandum, it is mentioned experience as in-charge principal. 1 mark for each year. Each year of experience subject to maximum 3 marks. Here, my lord, stated only year, my lord, not date, my lord. So, mark for each year.
What are you submitting, Mr. Sharma?
Here, my lord, it is stated in the office memorandum.
No,
28.
you have given him 2 marks. Where is the document to show that he was in charge principal for 2 years? 1 mark each year. Where is the document to show?
My lord, page 37, my lord. Here, order, my lord. It is issued on 31st December 2018, my lord. 31st December. Here, my lord. Until further order, Sri Jayanta Kumar Borman, MA B.Ed, the senior most assistant teacher of Belsor Higher Secondary School, Belsor District, Nalbari, is hereby allowed to hold the charge of principal in charge of the
Mr.
same.
Sharma, we know to read, and we have read it also. We are asking you what you have to. Which document of yours will show that this candidate had 2 years of experience as in charge principal? And from which period to which period was those 2 years? No answer.
In the
Yes,
office-
Mr. S.P. Sharma, on your experience, what you want to say? Other one will not allow you. Other regarding the ACR, we are not going to hear you because you are only an incidental beneficiary. You have no right to submit on that.
My lord, that is the main important, even if my lord's observation that I should get only 1 mark for the 2018, my lord, still the entire issue is with the ACR. My lord, that is why the order dated of 1/6/2023 of this Honorable High Court had directly stated that the ACR which he have submitted in his affidavit in opposition and in the petition itself are 2 different sets. Whereas in the record, there was only 1 set. So how did he produce a fake ACR? He has produced a fake ACR.
Lordship, I will object to that word.
My lord, may just
I
see.
have got it through RTI, your
No,
lordship.
my lord may see. My lord, may I
No,
just.
no, Mr. Sharma, we are not at all on that.
Yes, my lord.
Selection committee can give their views only upon the materials available.
Yes, my lord.
How did the selection committee know that in future Mr. Bothago's client is going to file a writ petition, and in that writ petition another ACR will be
No,
annexed?
my
How?
yes, my lord.
They are astrologers, your selection committee members.
My lord, the remark they have given is ACR are not found in original.
What ACR not found in
My lord,
original?
my lord may just, my lord may please look into page 36, annexus 7A of the writ petition, my lord. My lord, Gangadhar Burman, at the last, he does not submit the PSC pass mark sheet.
How can he submit the ACR?
My,
Mr. Sharma,
yes, my lord.
the authorities are the custodian of the ACR.
Yes, my lord.
How can you expect the candidate to submit his ACR? It is for the selection committee to call for the ACR.
Yes, my lord. When the ACRs were called for, the ACRs were found in originals.
Then where is the ACR?
My lord.
Whose fault it is? Is it his fault?
My lord, there was.
I think your client must have manipulated with this principle in committing some fraud. That is the only impression we are getting, because you see there is a selection for the post of principal.
My lord.
The authorities will be the custodian of the ACR. Selection committee will call for the ACR from the authorities. No employee is in a personal possession of his ACRs.
My lord, may I just submit here, my lord? My lord.
Then they tell us from then where did you get your original ACR?
My lord, may just.
From where? Please tell us from where did Jayanto Burman get his original ACR then?
My lord, those ACRs were committed. My lord, the entire case is about ACR. My lord, just may I allowed to submit, my lord, once.
You can go on submitting, but we have to also answer a question also, Mr. Sharma.
Yes, my lord. My lord, what had happened is that in an earlier writ petition which has been filed, the Honorable High Court had said that the entire exercise shall be carried out with regard to the submission of ACR after the selection process was done. Thereafter, an order was passed, and by that order, everyone's ACR was called into. And even those, my lord, may just may read page number 10.
Who had done this selection? Who are the members? Who are they? These people? The school selection committee represented by the chairman, namely the president of the SMBC of Belsor Higher Secondary School, to provide the information as to why the ACR of the writ petitioner Gangadhar Burman was not appropriately called for.
My lord.
List next week. I think that's your issue.
My lord has passed away with the order, but my lord may just submit if my lord allows me to. My lord may just look into page 50 actually, my lord. Of the writ petition, ma'am. As per your letter above, I am here to submit here with the ACRs of the three impaneled candidates for the last 2 years in regard to the appointment of regular principal of Belsor as per advertisement so and so. The name of the impaneled candidate of selection of Belsor is Jayanto Kumar Burman, ACR submitted by the ex-principal of the school.
Yes, with reference, I would have to honor to state that as per the order of the High Court, the requested the undersigned to submit copies of the ACR of the empaneled for the last 2 years. As per the order of the High Court, you were requested to submit the ACR of Gangadhar for the last 2 years. Very well.
Yes, my lord. So now, my lord, thereafter, after this, my lord, an order was passed appointing the petitioner. So now, my lord, what had happened? The ACRs that were submitted by the ex-principal as per this order is the one which he has given in affidavit in opposition, whereas the ACR
Mr. Sharma, we are not interested in that argument for one simple reason. Whatever he may have annexed in his writ petition is a future event. Okay. Can I pass a judgment on a future event? No.
Yes.
Selection committee will take note of only the ACR that is available on record.
Yes, my lord.
And you point out to one observation that ACR not found in original.
Yes, my lord.
If ACR is not found in original, it is for the selection committee to ensure that the original ACR is before them. Because candidates cannot submit their own ACRs.
I
A
absolutely.
candidate can submit his metric certificate, candidate can submit his MS certificate, candidate can submit his character certificate, but ACR he cannot submit because another authority is the custodian of the ACR.
I absolutely agree.
So you have to agree.
Yes, my lord.
And it is for the selection committee to call for the original ACR from that authority. The selection committee, having not performed its duty to the complete, cannot act to the detriment of one of the candidates.
My lord, may I allow me
You
to
don't have to go on asking me. You say what you have to say.
My lord, the selection committee, while conducting the selection, the ACR which is in front of you, those were the
Not
ACRs.
don't express these personal words. I'm not on with a personal conversation with Mr. S.P. Sharma.
No, my lord, I'm
You are saying you and all.
No, my.
Please don't.
No, not. No, my lord.
Maintain the minimum decorum. Yes,
My lord, I am saying that the documents which have been submitted by Mr. U. Sharma, I was U. Sharma before me, my lord, the records that was what the ACRs were called for by this honorable court to match whether the
Mr. Sharma, we are not at all interested in this thing. Once a selection committee undertakes to make the selection, it is for the selection committee to call for and ensure that the original ACR of the person is made available. Every employee is bound to have his own original ACR, which is not maintained by him, but it is maintained by the authorities. Okay. This is number one. In performing this duty, is some other document being not the original ACR is forwarded, it is for the selection committee to go back to that authority and ensure that the original ACR is made available, and it cannot reject a candidate for having failed in its own duties. And mind you, we are only hearing you as a beneficiary of an illegal order. And we are not here to allow you to justify an illegal order. You wanted to say something, we allowed you, but it is for the departmental authorities to make their submission, and not for the candidate who is the beneficiary of an order. Understood? Let them first satisfy. If they're wrong in telling something, we'll hear you if you can point out. Where is the original ACR of this man? He ordered Dilu. And Director of Higher Education, Secondary Education Assam is further directed to produce the ACR in origin of the Red Petitioner Gangadhar Burman for the years 2017 and 18. List on so next week.
Time being item 15.
Mr. U. Sharma.
Yes, ma'am.
Mr. S.P. Sharma may not like it. Most likely, one of these persons, either the SMDC or one of those earlier in-charge principals, does not like the face of Gangadhar Burman, ensure that his document does not go and he does not get it. Or else, if your allegation is that he had fraudulently manipulated his ACR in some manner, that is a totally different allegation. Okay. And another statement of Mr. Bothakur has caught my attention. He says, whatever ACR I have annexed was given to me under RTI. Who is that RTI?
Lordship,
Information
after passing
Authority.
I have obtained it from your lordship, the government, your lordship.
So he is not creating any fraud. Plus, ACR being under the custody of another authority, it is for the selection committee to call for that ACR. You cannot say if the original authority does not give the original, it's not a case to reject, it's a case to reiterate and call for it. Otherwise, you are discriminating against one of the candidates.
In the repetition, it is annex another STR, and in RTR it is another.
Mr. U. Sharma. Today we'll decide this repetition on the basis of material before us. Suppose in the Supreme Court, in the appeal, they bring in some more documents. Okay. Can my order be justified on the basis of those documents which was not before me? Number one. Do I have any occasion to foresee what is going to happen in future? How did the selection committee foresee that in the future writ petition, he is going to annex another ACR? How can you take advantage of that situation? You have to justify your act on the basis of the materials available. You have produced the records. That's the only records you have. And the records reveal that his case was not given because original is not found. Whose fault it is? His fault. Then? Yes, Mr. S.P. Sharma, you are always eager to say something.
My lord, the entire exercise, my lord, has passed the order. But the entire exercise was this, that there was the ACRs which were been, there was a second round of litigation. The first round of litigation.
We are not interested in how many rounds. We are interested, law requires his original ACR to be taken note of by the selection committee, of which he is not the custodian. It has to be brought from the authority who is the custodian. He should bring it.
Thereafter, that issue was taken up by the court, and thereafter, what the court did, the court directed that letter annexure 50, where they said that all the three ACRs should be called for, and after examination, we will pass. That he has to produce.
Who has to produce?
My lord, the government. Because that is what the annexure 50 is all about.
Government has to produce.
Yes.
Government should produce before the selection committee.
Yes, my lord.
So how can you take the advantage of government not doing something? Why didn't you produce the original ACR? If Mr. S.V. Sharma's allegation is right.
No, my allegation is not that. My lord.
Otherwise, we find it little incomplete country.
My lord, this is 49, annexure 14, page 49. This is from the inspector of school. That as per the order of the Honorable High Court and the Government of Assam, you are requested to submit copies of Sri Gangadhar Burman at your school for the last 2 years, presiding.
We have read that one already.
I'll know a letter before that. In regard to appointment of regular principal of Belsore High School, the teacher concerned applied as candidate for appointment against the post of regular principal, the Belsore as per advertisement so and so. The ACR of the employees concerned should be submitted in a seal cover to the office for submission to the government within 3 days. And thereafter, on 25th Feb 2020, the ACRs were given by the government official to the, and thereafter the order was passed for appointing. So now his
that cannot give something in your favor. Unless he gets a fair treatment, we cannot uphold your order. He has to be given a fair treatment. Suppose his ACR is very bad, you don't give him marks. Because good is 1 mark, very good is 2 marks or something like that. Something is written there also. Good 1 mark, very good and above 2 marks. If he's got a bad, then you don't give him marks. But his correct ACR has to be produced by the authorities. Without producing it, you cannot deny him that. This is what we are looking at. And you are not very happy when we say you have nothing to submit because you are an incidental beneficiary of an illegality committed to it. The illegal beneficiary is not a necessary party for that issue. For your issue, we understand. If something of yours had not been properly looked into, we'll give you full hearing. but not regarding the illegality done to him. That the government will explain, state respondent will explain that. Produce it, Mr. Responsible. The Director of Secondary Education Assam to also provide the reasons to the court as to why the original ACR of Gangadhar Burman for the given years was not placed before the selection committee, and who is the person responsible for the original ACR being not been placed. If any other authority is found to have been involved in the matter, appropriate inquiry and action be taken.
Public. A little bit of 18.
Sorry?
18. And otherwise it will be.
Whichever 2 years you have considered. We are not going to that question. If you have considered 17, 18, 17, 18.
No, my lord. It is that, my lord. I am.
No.
It is 13.
No. If you have difficulty with that, we'll prepone it. No, these things I can't remember for months together. When I say hearing is started, if it is within a closed time, at least I can recollect what happened today. After a long time, how can I remember?
Time being 15.
Yes,
Please,
madam.
Your Lordship, matter may be passed over for that only.
Adjourn on the prayer of MS.
I'm appearing for SSA, Your Lordship, respondent 6 and 7.
Pidas for SSA.
Lordship, matter may be taken on Friday.
As per your turn.
Deeply obliged.
Item 21.
What happened?
Lordship, in this matter, arguing answer, Mr. Itketa has left the court due to some personal difficulty, Lordship. Lordship, may fix it day after tomorrow, Lordship.
There is an urgency, my lord. If your lordship finds your lordship's order on 12/9, there is an interim order which has been passed by this honorable court, stalling the entire promotion, my lord, promotion of 17 principles of diet. Lordship has observed that the
It is more of a convenience.
Yes,
You
more
argue
of a
it.
convenience. Day after
No, we can't. Day after tomorrow is for some other litigants who are queuing up before they raise for their own turn to come. We don't continue with the interim order. We don't continue with the interim order.
Otherwise,
Or
it
else
is-
you argue.
otherwise
You
it is
argue
only
your on merit. Why do you want an interim order?
No, Lordship, you were supposed to be argued, Lordship, but due to some personal difficulty, he has.
No. Because of personal difficulty of one man, how can you put so many other people in difficulty?
Our
17 colleges are not
17
having their
colleges are
principals.
without a principal, my lord, regular principal.
17 colleges are there without principals.
And that is only from
And
one
why?
petitioner.
Because one interim order of convenience had been passed by the court without even looking into the prima facie case made out. This is going on for the last 2 to 3 days. We are only asking you, please argue on merit. Please argue.
Lordship, then please, Lord, take up at the last item, Lordship, I will take instruction, Lord.
Do whatever you do. Last item I'll take up
Last
here. Only one item is there. Okay, after that we'll take up.
Time being 27.
My lord, in this, my lord, I have taken an instruction, my lord.
That one.
Yes, contempt, my lord. There is one letter, my lord, which has been addressed to the senior standing council for preparing an appeal against this.
Against this order.
Against this order, my lord.
No,
I could
order
not-
is only to dispose of a representation, I think.
No, my lord, there
Or some finding is also there.
was there.
Finding is there.
Basically, my lord, the lordship will issue notice in the contempt application. In the meantime, my lord, I'll find out, my lord, if-
Secretary notice 666 of office 3 days. No, here is just registered post 3 days.
Time being 21.
Finally, one recommendation maybe
Well,
given
tomorrow.
Lordship
Well,
on
tomorrow.
tomorrow Lordship.
Well, tomorrow.
Tomorrow is the turn for many other litigants. See the rush before the registry to have the matters listed. So for one litigant, why should we go on repeatedly getting listing and depriving others? We don't make, doesn't make any sense
No,
to us.
Lordship, she is coming, Lord.
Who is coming?
HK Das, Lord.
Who asked him to leave the court in this manner? He should not. And this was pointed out to Mr. H.K. Das on the last two occasions, that see, you are holding an interim order to the detriment of 17 colleges. College or school? Schools, I think, higher secondary schools.
Colleges, diet college.
Diet college.
Colleges. Why? Because you have made out a case. And your interim order was also not passed on merit. It was only on the convenience that maintain a status quo something for one day, next day we are going to do it. And in this manner, almost 1 year has gone by. All we are asking you to, please submit on merit. If you have a good case on merit, we'll continue with the interim order. But why should 17 colleges be allowed to suffer because of this?
In fact, the other day, my lord, what we
Good
proposed-
thing high courts are not subjected to payment of cost. Had that provision is there, the 17 colleges would have asked compensation from the high court. That recklessly stay orders are passed and we are suffering. Mr. Nair appeared. Ask Mr. Nair to come then. We have seen Mr. Newman Nair also once. When interim order was passed, Mr. Nair was there. Ask him to come. He was here.
Lordship,
Ask him to come. We should not continue this way. Why, on the request of Mr. Nair, he sought for an adjournment for 2 days. Therefore, an interim order was passed. And it went on continuing.
In fact, the other day, what we proposed also, there were 17 posts which were recommended. Among that 17 candidates were recommended, one was promoted. That they have challenged and he has made a party. That person has retired.
Sorry, what happened? Please repeat.
Malad, the 17 persons were recommended.
No,
They
what is challenge in this writ petition?
Malad, their basic challenge is, Malad, the 2010 rules makes the principal as a promotional post. And there is no qualification as prescribed as PhD to be there for the post of principal.
2010 rules,
The diet
principal is a promotional
Promotional
post.
post. From the post
PhD is not a requirement.
Not a requirement.
Very well. Now,
2014 NCT prescribes that PhD has to be there for the post of principal.
NCT.
NCT.
What kind of institutes are these?
These are diet colleges. Man.
That means what do they do?
It says district elementary
Teacher training.
Teachers training.
So teacher training, NCT is a
Regulatory body.
regulatory body.
It's a regulatory body.
So now what is the grievance of this petitioner?
The petitioner says that the candidates who has been promoted, none of these candidates has the qualification of PhD. Now this candidates, there is a judgment of this honorable court. In fact, is there in the petition where this honorable court directed to promote the petition, to conduct the promotion as per the service rule of 2010. The 2010 service rule, which does not prescribe any PhD.
Whose
And-
case is that? That is your case.
That is our case. And 2010 rules has not been amended in terms of the NCT regulation which was passed in 2014.
Where is the order of the court?
Madam. Mother will find page 143. Mother will find page 148, last paragraph.
144, disorder.
Yes, 144.
Order dated 9/4/2019.
9/4/2019. My lord will find page 148.
Let us read the whole order.
My lord, may I? At so and so, so and so. Both the
Yes.
repetition. and fill up the vacant post. Principal in that. Like, eight. Well,
From where does MLAs and all come in between? No, no, page 145 for one local MLA.
there was some
Where is the finding of the court that 2010 rules
148 मतलब second last paragraph your lordship.
respondent shall fill up the vacant post including by following the provisions of
2010 rules at an early date.
and where is that
2010 rules.
NCT
NCT minus in the repetition your lordship.
113. Mr. Nayers, your case must be solely based on
NCT.
Madam Sinha. Oh, you were there. 116.
113.
113
start. One 5.2. 116. 5.2 qualification.
What is this workspace? This is a part of some rule or
This is a part of that gazette, man.
Gazette.
no gazette. It is
Appendix
notified in the gazette. What is it? Some regulation or
It's NCT regulation.
some NCT regulation. To what extent it is binding?
The colleges under this cannot go beyond the NCT regulation. They'll have to follow the NCT regulation. Whatever
Then
norms
the
are laid on, like my lord,
no. Then the order of the court is again.
because that aspect was not brought to the notice of the court in that case. My lord will not even find a reference anyway. Because
Yeah,
they have-
that's why I read the whole order. It's not there.
It's
Only
not-
some
no reference was
MLA
made.
recommendation and all that.
that because went on that plea only, my lord. But when
And
the
now, as per this one, you have made the selection as per the 2010 rules,
2000.
where there is no requirement of PhD.
PhD.
And selected people have no PhD.
They have
May or may not have PhD.
Lordship.
Yeah.
Petitioner is agreed by that.
Lordship.
This is the issue.
Lordship.
And
I
after
say
the
when they-
2014 my lord.
We'll decide it on Friday. Okay. I don't know what to do.
No, my lord, Assam government has not adopted. Assam government has adopted.
Now,
in
this
a
question I
particular manner.
said,
Yes. 2000 my lord, page 127.
have you adopted the NCT regulation?
Yes,
in a-
page 127. my lord.
Yes.
The
One
notification to the
20.
extent of the lecturer.
At the entry level, it is, that means, my lord, idea is to apply it prospectively.
Lecturer 127. just a minute.
127.
Second paragraph.
Government of Assam, where is it? The education the Korean NCT.
Keeping above in. Governor of Assam is pleased to revise the existing minimum qualification for all categories of post of district institute so and so as per norms and standard prescribed by NCTR.
The idea was to apply it prospectively. Whoever is already there, to them the idea is not there.
And this is a selection of which year?
This is Mala 23. And my lord will have 141, their own stand, my lord. Page 141. It's a minutes. My lord will have 1, 2, 3, 4th paragraph. My lord, my friend will, he is prepared in this, he'll take over.
But I'm sorry.
My lord, this is again a distorted one, my lord. As one time practice
Just a
only,
minute of the.
where from they get it, my lord? The last sentence of that paragraph, as one time measure only, it is not there in this paragraph.
May I just start with the?
Yes.
I'm sorry.
খাইতে পৰা যাবনে শুনি নাপাৰি এইটো শুনিব লাগিব শুনিলাখন পাৰি এই থাৰ্ছডেটো থাৰ্ছডে শুনি দিলোঁ হয় ফ্ৰাইডে Friday we'll find out time for this matter.
Not take long time.
And list along with WPC 2293/2019.
Yes.
That judgment which
No, that I have annexed below.
Oh, my lord wants the read of that.
No records.
Yes.
Under what circumstance that judgment was delivered? We want to look into
Also,
that.
we'll have one more thing, my lord, they are heavily relying on that resolution. But in the state's affidavit, they say there is no such resolution of that.
This page 141.
Yes.
And the state also you produce the entire records. Complete records of whatever had happened. Not only this election, of whatever had happened from before and after also. Complete record. The state authority is going to also
both the
produce the
records
complete
of earlier
record.
selections of.
And where is the beginning of this NCT regulation? I think only relevant parties are next, I think.
No, it no. Well, I'll give the entire bunch. Yes,
Entire thing.
I understand.
The authorities in the state government to also provide the information as to whether the NCT regulation, what will be that year of that regulation? 2014 had been adopted for the purpose of filling up the post in the diets, including that of the post of the principal, posts of the principal. And
My lord, the NCT regulation was amended whereby this requirement was.
and if not, why? Let us take a wholesome view, because this one, what it appears, in one way, we can take
Only
a.
thing is, my lord, two of the respondents are retiring in this month.
We do it on,
Already DPC proceedings are
we
there.
do it on
Friday is
Friday if necessary. Because one way, if you look, we have to go in their favor.
Yes.
Another way we look, we have to go in your favor.
They'll have to challenge the rules. They'll have to challenge that why Assam government has, nothing has been done. The seniority list is not under challenge.
No, we don't go by this micro thing.
Somebody has to come within the.
No, we are going on the macro aspect, whether the 2000, not these micro aspects. Micro aspect, the committee will decide.
Nothing would recollect in some of the decision where this honorable court has also accepted the view, there is a requirement of adopting.
Mr. We say one way we can look, I find some answer in their favor, another way look, I find answer in your favor. So when we are finding two answers, we have to go one step more.
my lord.
If you want the answer, I can give also. Why in your favor and why in his favor?
I'll get that instruction.
Ultimately,
extent of adoption of 2014.
ultimately, no. Ultimately, okay, we'll tell you on Friday. If I tell you now again, start again.
14 has been adopted in 2020 only for the lecturer. For principal, why it is not adopted?
No, not only adopted. Is it binding or not? That is another question, because NCT, these are teacher training. It's a very, very vital subject. If NCT is provided something, if it is not adopted, the quality of teacher training may go down, and the quality of teacher training going down, the quality of education imparted to the students will go down. That we have to, that's why I'm saying take a more wholesome view.
Another view would be, my lord, whether that amendment which was introduced in 2017 that will apply prospectively or retrospectively.
17, some amendment is also there.
No, my lord, this requirement of doctorate was brought in by an amendment.
In 2014, in 2017.
No. Hi. No. Principal kind of 14 it's there in form 14 regulation is there. I'll bring the entire regulation.
14.
Yes. Sorry. My understanding is correct, madam. For lecturer.
So we'll have to balance the two.
Yes.
Ultimately, let's see how we can best begin.
Proceed, yes.
My friend will bring the records, my lord. My friend.
Bring everything.
Selection.
And we don't want to continue with this matter because today I heard it because one stay order was on convenience, not on merit.
Yes.
So we find it difficulty to extend a stay order in convenience without at least hearing what is the issue is about.
Is being satisfied.
At least something is there. So Friday we'll try to finish.
My lord will also indicate, my lord, the records of selection.
All the records.
My lord will kindly continue the interim prayer, my lord, till today.
Don't worry. For these 2 days, they won't do anything.
They will not
Anyway,
do
we'll continue till Friday.
Yes.
We'll see to it. It also.
Partially you'll succeed, partially